Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 11th, 2026. We have 11 bills on the docket. We're going to start off with Senate Bill 360, and then we're going to go to 362, 465, 454, 365. Actually, we're going to skip that. 475, 437, 464, and 397, 406, and we'll round out the day at Senate Bill 407 with Senator Guile. But right now, if the senator is ready, Senator Henson, if you're ready, we'll start off with Senate Bill 360.
Thank you, Mr. Chairman. May I bring up the panel as well? Thank you. I think we have from Maryland State Police, we have Justin Foys. I think we also have Brian Gills from Sleola, and then David Lewis as well. And I think that's our panel. For the record, colleagues, I'm Senator Shanika Henson on behalf of Senate Bill 360, Criminal Law, Emergency Response Animals, Prohibited Actions. Mr. Chairman, Mr. Vice Chairman, and members of the committee, this bill is here today before you that will create definitions and penalties for intentionally harassing, interfering with, injuring, killing, or causing serious physical injury to animals used by law enforcement and rescuers to provide emergency response services. Current law provides only one sentence to protect these highly trained animals. In this bill, emergency response animals are defined as and include dogs used by and trained for law enforcement work, horses used for law enforcement work, and search and rescue dogs trained for and engaged in efforts to locate or rescue lost, injured, or deceased individuals. Today, you will hear examples of situations regarding the critical nature of the work that law enforcement animals and search and rescue animals provide. These animals regularly find themselves in harm's way, as do their handlers. We need to protect law enforcement and search and rescue animals from harassment, interference, injury, and death for the important and critical work that they provide. We need to also remember that these animals are highly trained professionals, and they provide critical tasks that help with things such as finding missing people, tracking suspects, detecting explosives, drugs, and human remains. They protect officers and civilians in dangerous situations, and we need to make sure that they similarly are protected. So what I'll do is defer to the panel that's here today, who will share with you some additional expertise and hopefully make the case for this bill. And with that, colleagues, I will urge a favorable report on Senate Bill 360. Thank you.
Good afternoon. I am Brian Gill, the president of State Law Enforcement Officers Labor Alliance, known as SLEOLA. SLEOLA is the exclusive representative for about 1,750 sworn active law enforcement officers in the state of Maryland, which includes the Maryland State Police, Natural Resources Police, Fire Marshal, Maryland Capitol Police, Department of Health Services, Motor Vehicle Police. This Senate Bill 360, it defines emergency response animals, including search and rescue dogs, clarifies penalties for the act against both law enforcement and search and rescue animals. SLEOLA supports this proposal as in efforts to specifically protect the animal that face the same risk that law enforcement officers do on a daily basis. These animals are sent into dangerous situations and they protect their human officer and the people of the community. Maryland law enforcement agencies are highly trained police dogs for detection of narcotics, explosion, and cell phones, tracking, apprehension, and locating of missing persons. The Maryland State Police and Department of Public Safety and Corrections have significant units, employed breeds, including Belgian Malinois, Dutch Shepherds, Labrador Retrievers. I have a few examples I'd like to give. First of all, I have one dog here today that was actually directly involved in an incident where was working for the Baltimore Ravens game as a bomb detection dog. A drunk individual came up behind it and struck the animal. When those type of things happen with these animals, it actually affects them both mentally and physically, where they're afraid of crowds and they don't want to work. The state of Maryland has put a lot of money into training these animals, and it's a big loss when they get treated like this. I'll just end my time with that, and that SLEOLA requests a favorable report. Thank you. Yes, sir.
Good afternoon, committee. My name is Dave Lewis. I'm a first sergeant with the state police, and I'm here as the vice president of Sleola. First, I would like to thank the senator for introducing this bill and supporting us. Basically, why we're here is this incident that happened at the Ravens brought it to light. Once it happened, we didn't realize there weren't any laws on the books to protect the dog. So we didn't know that we didn't already have this established. So we thought this is kind of a common sense law to protect the dogs. These dogs are obviously working. They're here to support you. You guys are familiar with the dogs that go around and clear the chambers downstairs. So the dogs are very valuable. And when they do get assaulted, they are like members of the family to the officers. So I don't know if any of you have pets, but it's hard to keep it separate, professional and personal. So it means a lot to them. So we wanted to support them. We also have search and rescue here. The Western Maryland Canine Search and Rescue wasn't able to come here in person, but they did submit written testimony, if you could read that. The only thing that they were looking to possibly do is get an amendment. We were unfamiliar that there are search and rescue horse. So it does say police horse in here, but they do have search and rescue horse that we would like included if possible. Other than that, I just want to say me too to what Brian said, and Sleola asked for a favorable report for 360, and thank you for your time.
Good afternoon, Mr. Chairman and members of the committee. My name is Greg Miller. I'm an operational canine handler with Chesapeake Search Dogs, an all-volunteer, nonprofit search and rescue team based in Maryland. I'm here today on behalf of the handlers and, more importantly, the dogs who find lost and missing Marylanders. Search dogs do not understand the laws protecting them or why someone would wish them harm, but they understand training, trust, and a simple task: find the person who needs help. When a child goes missing, when an Alzheimer's patient wanders from home, when someone doesn't make it back from the woods, it's these search dogs who are called out by Maryland law enforcement and fire departments to find the missing. The reality is these dogs are asked to work in dangerous areas, in darkness, around unpredictable people and unknown hazards. They work through exhaustion, hazards, and danger because they are driven and trained to complete their tasks. They protect our communities by finding the lost, giving families answers, and allowing victims a chance to come home. And yet, under the current law, these working dogs are not adequately protected from interference with their duties, deliberate harm, or even intentional killing. Protect the dogs who protect Maryland's lost and missing. That's the heart of this legislation. Interfering with a working search dog doesn't just endanger the animal, it delays rescue, jeopardizes victims, and puts handlers and emergency personnel at risk. Injuring or killing a trained search and rescue dog destroys years of training, thousands of volunteer hours, and a vital resource that cannot quickly be replaced. Strong legal protections tell volunteers in Maryland the value of their service and that the dogs who stand between life and death are worth defending. This bill sends a clear message that Maryland will not tolerate harm to those who serve the helpless. On behalf of our handlers, our dogs, and the people we rescue, we ask you that you provide a favorable report to this bill. Thank you very much.
Thank you, Mr. Chair. Thank you, Senator, for bringing the bill, and for all of you for being here and for taking care of these amazing creatures. And it's really more of a thank you than a question. This is amazing. They're family members, so we appreciate you.
I couldn't agree more. That's great. Any further questions from the committee? We're just echoing the sentiments of the senator. Oh, sorry, Senator McKay, go.
And understanding commands and all the verbiage that you went through. I actually thought you were explaining members of the JPR, but then it dawned on me we were talking about the service dog. So, but anyhow, thank you.
I'll take that as a compliment.
Oh, absolutely, absolutely, and we did too. I mean, that was a real good compliment for us. So.
That was good. If you read everything they say about you, But, all right. All right. Well, thank you all very much. Thank you very much. Thank you.
Thank you.
All right. With that, that will conclude the testimony for Senate Bill 360. We'll now move on to Senator Attar with Senate Bill 362. Would you like to bring up your panel? Yeah.
Thank you.
Thank you, Mr. Chair and members of the committee. So as you may recall, last year I was before you with this bill at the request of State's Attorney Ivan Bates. And this bill is titled Child's Access to Firearms Penalty, the Nicaila-Straughter Act. This bill unfortunately stems from one of several tragedies that happened in my district, and I know it's been in other districts as well. The reality is we have individuals who have firearms and leave their firearms unlocked and in unsafe places where children can get access to it. And unfortunately, we have deaths as a result of it. I'm not going to go into detail again like I did last year about Ms. Straughter, because we do have her family member, Ms. McCrae, here who will talk about her and her memory. But I do want to say we do have Ms. Brady here, Assistant State's Attorney Jennifer Brady, who was the one who was the prosecutor handling that case, and she will discuss details about why this bill is necessary. I want to say that I was reading over the opposition, and what this bill does is it increases the penalty for someone who leaves that firearm from a fine of up to $1,000 for up to 5 years of incarceration. So I was reading some of the opposition, and one comment was, well, there's the reckless endangerment charge. Why do we need this? And Ms. Brady will get into a lot more detail about that and why that's not sufficient to prosecute a case that involves this. But I just want to say that it's specifically said, well, if someone leaves bleach out, we don't say, okay, we're going to need a separate charge and a separate amount of incarceration. Leaving bleach out where a child can get it, that is reckless. Leaving a firearm out, a firearm that is very different than bleach under the laws of the state of Maryland and under federal laws, is a very different situation. And this bill is there in order, one, to deter individuals, but also as consequences, because we do have tragedies that occur, and there do need to be consequences when a tragedy does occur. So with that, I ask for a favorable report, and I'll turn it over to my panel.
Good afternoon, Chairman and committee members. Thank you for having me here today. My name is Jennifer Brady, and I come here really in 3 roles. One is a mother of school-age children who just recently, my children were coming home and telling me how they had a drill about how they were hiding under their desks for an active shooter drill. I'm coming here to you as a prosecutor with almost 20 years of experience. I'm on the front lines of these violent crimes, being the voice for victims of those violent crimes, including the terrible case of Nicaila-Straughter. I'm also coming to you as a professor. I'm an adjunct professor at UB Law, and I teach a course specifically on sentencing and plea bargaining. And all of those roles give me a unique and comprehensive perspective for this bill. I have submitted written testimony, and so you all have hopefully read that testimony in support of this bill. So I want to spend this time specifically addressing some of the counter arguments or some of the issues that have been brought up in response to this bill. First of all, the reckless endangerment statute and redundancy issue has been brought up. I want to address that. When I went to charge the case where Nicaila-Straughter was killed, and I was looking at what charges were applicable, reckless endangerment was one of the first statutes that I looked at. But I saw in that reckless endangerment statute a hurdle, the problem of reasonable, foreseeable consequences getting into the mind of the individual who committed this reckless endangerment is extremely difficult. It's extremely difficult to get into the mind of a defendant and try to prove that at trial. And so I knew I was going to have a hurdle, and in fact, I barely, based on the judge's responses to arguments by the defense during motion for judgment of acquittal, I barely got over that hurdle. Some prosecutors don't even choose to charge reckless endangerment.
Your time's expired. And the reason I'm being a little bit more strict on this is because I want to make sure that every witness has the same expectations in this. But I assure you will be asked some questions, so you will definitely have an opportunity to expound upon your testimony.
Fair enough. Thank you, Chairman.
Very much.
I appreciate it.
Dear Chair, Chair Smith, and members of the Senate Judicial Proceeding Committee. On August the 6th, 2022, my world was turned upside down. When I lost my beloved niece, daughter, Nikayla, to gun violence. Her death was a result of someone not properly securing their firearm, a tragic oversight that has haunted me and my family every single day. Because of this failure, I'm now left to navigate life without her. And I can't help but wonder how many other families are experiencing similar grief due to preventable gun violence, gun-related tragedies. On December the 22nd, in honor of Kayla, my decision was to start an organization decided to create safe spaces and places for children to play and grow. Our mission is to ensure that no child has to face the dangers of unsecured firearms and to provide communities with resources and education about safety gun stores. Since Nikayla's death, I've been heartbroken and increased number of children that I've been seeing increased number of children dying due to firearms that are not properly locked away or stored out of reach. This year, 2026, Nikayla would have been turning 19 years old on March the 15th. She had much potential, so much life left to live. But because someone failed to secure their weapon, she is no longer with us. I ask you to take action to prevent this senseless gun violence from happening to other families. It is crucial we pass laws requiring proper firearm storage and raise awareness about the dangers of leaving firearms unsecured, especially around children. I urge you to take meaningful steps to protect our children and ensure that tragedies like mine don't continue to devastate issues. I trust that you will make the right decisions that will create safer communities and protect lives of our future generations. Thank you.
All right. Thank you very much, Ms. McRae. I want to say thank you. Obviously, I've known you for a couple of years, seen you come down and your family come down for a couple of years. So I just want to say thank you for your continued advocacy. And from the committee to you, obviously, we extend our condolences and just we appreciate you. So thank you for your testimony today. Questions from the committee. Senator West has a question, and then Senator Sidnor.
Thank you, Mr. Chair. For Ms. Brady, you're a state's attorney, and one of the opposition says that this penalty won't do anything to promote safety because there are existing statutes on reckless endangerment, which should suffice. Could you respond to that, please?
Absolutely. So as I was saying earlier, the reckless endangerment statute is broad, extremely broad. It also requires a foresight, to prove the foresight of the individual, that they would know that what they're doing or should have known what they're doing would cause a specific harm, which is a very difficult standard to meet.
You have to get into their minds. You have to prove what was their mental
what's
intent.
in their minds,
Right.
which is extremely difficult. And usually we can only do through circumstantial evidence, and sometimes we don't have that at all, which is why sometimes prosecutors don't choose to charge reckless endangerment when a loaded firearm is left within the access of a minor because of those challenges. I happen to, in front of a specific judge, just slightly jumped that hurdle and was able to prove reckless endangerment in my case. But it was tough, and it was a tough motion for judgment of acquittal that I almost did not survive. Therefore, I believe that there needs to be we're not asking for a new law. This law already exists. This is only a penalty provision.
Thank you very much.
Of course. Thank you, Senator.
And just so that the committee is clear, you and the state obtained a conviction under the reckless endangerment statute that already allows incarceration for up to 5 years, correct?
That's correct.
So Ms. Gaskins, she was prosecuted.
She was.
All right. Is it fair to say that the issue in the Gaskins case was not the absence of incarceration authority, but the court's determination that the elements of 4-104 were not proven beyond a reasonable doubt?
So specifically with this legislation, we're not looking to affect Ms. Gaskins' case. That case is closed. It's over. With this legislation, we're looking at the future cases, future harm that we can avoid by this bill. That's what we're looking at. We can't change, unfortunately, Ms. Gaskins' behavior. Unfortunately, Nikayla, we can't be brought back. But what we can do is save the lives of future children.
But the statute worked. The statute that's on the books, it worked. Someone is being held accountable, correct?
By a $1,000 fine? No, we do not believe that that's appropriate. We believe that the $1,000 fine for leaving a firearm in access to a minor is wholly insufficient to deter that behavior.
There was a conviction under the reckless endangerment statute in local Baltimore City ordinance, correct?
It was not under a Baltimore City ordinance. It was under the state law for reckless endangerment. Yes, there was a conviction in this case. However, again, it was extremely difficult to prove that the elements required for reckless endangerment. And therefore, many prosecutors don't even charge it reckless endangerment in cases like this because it's so difficult to prove those elements when you're leaving the firearm. With these specific facts, it's very difficult, unfortunately.
Okay, help me to understand, because I have before me information that says there's a Baltimore City ordinance that deals with an unloaded firearm.
Oh, I'm sorry. I thought you were discussing the reckless endangerment. She was also convicted of the Baltimore City ordinance, correct? But obviously that only applies in Baltimore City. It wouldn't apply in any of the other counties.
So there was a conviction, and you're saying that the only thing that happened was that there was a $1,000 penalty between both of these statutes?
No, the $1,000 penalty is for the current penalty for the criminal law article that we're attempting to get a 5-year penalty added to. Ms. Gaskins got several years of incarceration. But again,
and that's what I'm trying to understand.
She did.
So then the question would be, why are we pushing for a legislative response to increase punishment under this statute rather than looking to try to figure out the elements that may not have been sufficient to sustain a conviction?
we could do both. But right now, in front of this, what the bill that's actually in front of this committee is adding the 5-year penalty, which when we're talking about habits, bad habits, not wearing a seatbelt, for instance, there's been many studies that have shown those types of bad habits can be curtailed by increased penalties. The deterrence does work in those cases.
And the penalty currently is, under the current law, is 5 years, up to 5 years, right?
No, it's currently the penalty for leaving a loaded firearm within access to a minor.
Reckless endangerment, I'm sorry.
Yes, for reckless endangerment, which is a separate crime. It's overbroad and doesn't actually address the loaded firearms. Firearms are treated differently because of their lethality. Firearms are regulated more than.
Let me back up for a moment.
Of course.
All right, just to make again, I'm just trying to be clear. You were successful in using the reckless endangerment statute that provided up to a 5-year penalty. Do I have that fact correct?
In this case, yes.
So this statute can be used by the prosecution to hold people accountable for up to 5 years. In cases
It has the
like,
possibility to, yes.
I mean, everything has the possibility. Okay, I got you.
Well, there's a difference between a bill that would have 5 years for specific acts being illegal. The actual act of leaving a loaded firearm in access of a minor, that would be illegal and subject to 5 years. There would be no extra elements that would need to be proved to get into the mind of the offender. That's the difference, is that we're specifically saying, you know what? We think that leaving a loaded firearm in the access of a minor is so terrible that we are going to give it its own, and the body has already done this. The legislature has already passed a separate bill. We're not asking for a new law on the books. This law already exists.
But it sounds to me as if you're arguing that there's a proof problem and that I'm trying to get at.
Yes.
But this bill is a penalty issue and you're increasing penalties.
Correct. The proof is with the reckless endangerment, not the bill. Not the proof that I'm talking about is for reckless endangerment.
But if there's a proof problem, why is there not a bill to deal with the proof problem that came up in this particular case rather than increasing penalties? When to my knowledge, everything that I've looked at says that increasing penalties isn't necessarily going to stop bad behavior. It's the certainty of being prosecuted and held accountable.
So it depends on type of crime. So as a professor, I've done a lot of research into studies on deterrence. It's one of the things I teach.
Okay.
And it depends on the type of crime. Crimes of passion, violent crime, those are very rarely deterred by larger sentences. However, habit crime, bad habit crimes such as speeding, seatbelt, leaving a loaded firearm in the acts of a minor, those crimes, studies have shown that increased penalties do, in fact, make a difference and deter those crimes.
Thank you.
Of course.
For the senator, I was looking at some testimony, and it talked about how the original legislation, it looked to mandate sins for the child who gained possession of the firearm and enhance the potential penalty for an adult responsible for safekeeping the firearm at issue. And in 2023, the testimony says this legislation was Senate Bill 15 and Senate Bill 656. And Senate Bill 15 was the mandatory sins, and that passed the Senate unanimously. The penalties portion didn't. But again, as I was asking our friend from the state's attorney's office, this seems to be focused on the penalties portion, and but it's also entitled and named after Ms. Strader, and so it seems to be a different bill. So what's going on?
Thank you for the question, Senator. And I know which testimony you're referring to. I actually was asked by State's Attorney Ivan Bates last session to put in this piece of legislation, and I went ahead and put it in, and it's now been over a year since this legislation's been introduced, and the first time I heard of these concerns was yesterday when I looked at the testimony online. They have not been brought up to me before, but when you say the original bill, this is the original bill that I was asked to put in by the State's Attorney. There was no bill before that I was asked to put in. I don't know the intent. I don't know the background as to why someone else put in a different bill in 2023. I don't even recall until I read that testimony that there was a different bill in 2023. I was asked by State's Attorney Ivan Bates last year to put this legislation in with the request and the help of the family. As you've seen, they're here, and I spoke with them outside as well, and I heard their thoughts on this as well. And I was asked again this year, because it's not passed last year, to put it in. So I cannot speak to what another senator did in the past, and I was not on the committee. I don't know why one portion passed. I guess the committee did not want to pass the penalties at the time, but we are asking in this specific bill to increase the penalties. And I do want to just mention something from what you were saying before about reckless endangerment, and I know Ms. Brady was telling me this before, that a concern a lot of times with increasing penalties is that prosecutors then stack charges so they can get 5, 10, 15. Ms. Brady was telling me earlier that there is case law that she found that says that it will not stack. If they are found guilty of both, they can still only get a maximum, it merges, a maximum of 5 years. So if someone's found guilty of both charges, they'll still get the maximum 5 years. Did I explain that correctly? Yes.
One of the, and I know you said you had the family here, and I'm trying to remember a few years ago, I think there was a gentleman who had spoken who, right, I think he's sitting behind you.
Yes.
And I think, if I remember correctly, some of his testimony, it seemed to be something, the testimony was, to me, and I'm not using his words because I don't remember his words from so many years ago, but it seemed to be something about healing community and not necessarily being a piece of retribution or the like. And whenever, again, when you're thinking about an increase in penalty, that's punishment. And I thought that I remembered that not necessarily being the main thing behind what the family was looking for, because I mean, I mean, I don't know if maybe if you're,
I can't speak to what he
right,
testified to.
but I don't know if maybe your other witness. I mean, maybe she remembers.
I do want to say, so first I can't speak about what he testified to a couple of years ago, but I will say that we were only allowed to have 2 people testify on the panel, which is why. I'm sorry?
Is it all right if the gentleman, I remember him testifying a number of years ago.
I
signed up today too, but I was told I couldn't speak.
I can just tell you, not to speak for what he said a couple of years ago, a couple of minutes before we entered here, he was saying that he wants this bill to pass. And
okay.
The bill as written, but
Thank you.
again, I wasn't here a couple of years ago.
No, this is for the state's attorney. So this was, actually, this statute was my bill in 2023. It was called Jalen's Law at the time. But Jalen, remember, she was killed by a 17-year-old who had access to their parents' firearm. And so we named it in honor of her, but that's the initial statute. And we actually garnered bipartisan support from this committee, members of this committee. But one of the major debates we had was actually on this penalty provision. And we settled on the $1,000 fine because the scenario of, let's say someone was negligent, had left something out, and someone got the firearm, and unfortunately the child killed themselves or someone injured someone else. And then the discussion centered on, not only did that tragedy exist, but then you're going to put the parent in jail. And so what does that do to the family? And is that so we had a really deep policy discussion as to whether that's the right thing to do under those circumstances. Of course, we all wanted to make sure that people store their firearms. And of course, we want strong incentives and education for that. But we wondered why putting a parent in jail after having lost their child would be the proper policy outcome. And so we settled on the $1,000 fine. I'd wonder just what you think about that.
Thank you, Senator, for that question. That's a very good thought process. I can see how that would be difficult. However, I can tell you that being in the front lines of courtrooms day in and day out, when family kill family, even in first-degree murder cases, you know, the judicial system, nobody's happy. Nobody goes home happy. In every single case where there's a defendant, their family is destroyed, whether they had anything to do with the case or not. And so when we're talking about once a tragedy has occurred, and we're talking about what should the results later be for the offender, there is no right or wrong answer. It's per case. It depends on the facts of each case. Allowing for a maximum penalty of 5 years does not mean that everybody that this happens to is going to get 5 years. We have to trust our judges that sentence individuals to use their judicial discretion to, when it's appropriate, give them up to 5 years. When something is so egregious, let's say a parent has left their gun out multiple times, the kids has taken it to school multiple times. That's what happened in this case. Ms. Gaskins had left the gun out loaded multiple times, and the grandson had gotten access to it over a long course of time. allow a judge to go up to a 5-year. Right now, it's $1,000 and that's where it ends. But looking at the specific case, like we always do, we never take a specific instance. We look at every offender. Every case is different. Every offender is different. And using that judicial discretion, using that prosecutorial discretion, that's how you determine the sentence. And again, nobody's going to win.
No, I appreciate that. Thank you for that, for your thoughts on that. But I would say, I'm talking about judicial discretion, but I'm not going to say something cheeky. You know where I'm going with this, but
Neither am I.
yeah, all right. Youth charges adults, just let the judge decide. All right, pass that message on. All right, good. Senator Fulton.
Thank you, Mr. Chair. So if you want to step up, Senator, thank you. I guess the question I have is my understanding is, looking back through testimony and through previous years, was that the real crux of this piece of legislation was the idea that we would have some sins law that would come into play that would add the penalties or another early intervention type of recourse.
That was in the crux of this piece of legislation.
No, not this one, but the one that was named for the namesake earlier.
So I can't speak to that. I wasn't the sponsor of that bill. I was not involved with that bill. I wasn't on a committee that heard that piece of legislation, and I don't know the intent of why that bill was brought. I can say that I was asked by the state's attorney again last year to put it in this way, and there was no sins involvement in this specific
Understood.
bill.
So, and, right? Okay, all right. Because much like the chairman said, and I mean, I don't know if the state's attorney or the, not state's attorney, but the professor wants to speak to it, but, you know, it's a pretty hard thing to say when you're saying that family kills family and it's a first-degree murder. This is something that, when we look at the specifics of this case and a 9-year-old, you know, person that has to live with this, I mean, you know, these people have to live with this for the rest of their lives, so.
If I can just respond to that. I know it wasn't a question before it was, and it was to Ms. Brady. So as Ms. Brady said, there's judicial discretion and things like that, but there's also, I was a prosecutor for many years, and I saw it. There's also prosecutorial discretion as to whether or not you were going to charge something. There are many situations where it's not a family member that leaves the gun out. If I send my kid to a friend's house and their parent leaves a gun out, and they do it all the time, and then my kid gets it, that's not a parent going to jail for it. So it's having this law in the books doesn't mean it's going to be sending parents to jail. It means there's that option.
I guess I just would have liked to have seen it been more focused around the sins opportunity to get a child out of that.
I thought from reading the testimony that you're looking at wasn't that incorporated into a larger piece of legislation? So it was passed, so that did happen already.
All right.
This is just the penalty aspect of it.
Okay, thank you.
Sure.
So I, too, was not here when prior legislation was here, but I feel like in the testimony and in the responses, there's a miss in terms of, I think what I'm trying to understand is your intent as the sponsor, so not necessarily an understanding of prior legislation or what any previous sponsor or prior bill was seeking to do, but just understanding your intent as the bill sponsor currently. So this is a bill that would enhance the penalties for someone who's charged with and convicted of a crime. So just understanding your position there. And I think what the chair was saying in what the committee had previously considered prior to my time on the committee, either of our time in the Senate, is that in these circumstances, the fact patterns that have been presented to the committee, that sometimes in these specific fact patterns, there were times where perhaps a harsh criminal penalty wasn't going to be the holistic solution that would bring about the sort of solution that would solve the underlying issue that the committee was trying to get at, that sometimes punishment is an appropriate remedy because that's how someone is able to atone for and then figure out, the tools to do better and take the next appropriate step. But that there's some times where maybe a harsh criminal punishment is not the way that a person figures out how to atone for and take the next appropriate step. So as the bill sponsor, looking at a bill where we're trying to decide, is the criminal penalty being harsher and having more of a punitive approach and having a harsher criminal penalty, as the sponsor, I want to discern and understand your intent and philosophy when it comes to a criminal penalty enhancement.
Thank you for that question. So I know Ms. Brady did say a lot, and I'm not going to repeat it because a lot of what she said before I agree with. But in terms of this specific bill, it's not a mandatory minimum, right? So I understand that if it was 5 years of incarceration, you're getting it, that's a concern. This is up to 5 years. There are times when it's necessary, as Ms. Brady was saying, if someone keeps leaving it out, there are times where it's necessary that you do need a period of incarceration. But like she said before, it doesn't mean someone's going to get it every time. And in fact, it doesn't even mean the state's attorney is going to charge this charge every single time. There are situations where it won't be appropriate and they're not going to charge it. And I've seen that many times myself, where at times they don't charge it. But the main reason why I would love to see this bill pass is because reckless endangerment should be used for things like, I left my bleach out because I was just careless, and situations like that. Firearms are treated very differently. They're treated differently by the law. They're treated differently by the state law, by city law, and by federal law. I do believe that it's more important that people realize, wait, this is very, very serious. And I understand the policy concerns that the committee at the time decided, you know what, we're not going to increase the penalties. However, from hearing about the experiences that prosecutors have with charging and prosecuting reckless endangerment, I do not believe that that's sufficient for something like this. And the fact that you can't stack the charges, you can charge both of them, but they're not going to get 10 years in jail. I believe that makes a huge difference because I understand the concerns with stacking charges. I've seen it happen. I understand it's a concern because prosecutors at times do it when they shouldn't be doing it. So I'm very comfortable with the bill as is because even though they can charge both, the penalties don't double.
Okay, I just wanted to be clear about your comfort level with the bill and the enhancement of criminal penalties and understanding where your intent was as the sponsor.
Thank you, Senator. Thank you.
Thank you.
You see, I think the committee reached the, sorry, I'll refrain from comment until after you. So, Senator McKay.
Thank you, Senator, for bringing the bill. So I guess my perspective is from a layperson. I can't imagine anybody intentionally leaving a firearm with the intention of that somebody is going to get it and then harm. I guess my question is, how does the potential increase in penalty result in a layperson understanding more education about firearms? I don't know how this equates to this.
So that's a great question. I do have to begin by saying I think this is my first bill that every senator on the committee asked a question. And also somehow I managed to get both sides of the aisle to not like a bill or question the bill. But in all seriousness, I'm going to go back to what Ms. Brady said about, and she's the professor and has analyzed this, about the studies. And the studies show that the penalties can change habit. And this is a matter of habit. And I can say from knowing people who are gun owners and being one as well, that sometimes bad habits lead to bad decisions. But when you know that there's studies out there and data out there that says that penalties can change bad habit, I do believe that this will help down the line. Now, it's not going to help in every situation, but it can help down the line.
Well, my only pushback on that is, unfortunately, data doesn't necessarily always correct behavior when it comes to educating somebody on the importance of it. When a police officer pulls you over for not wearing your seatbelt, I'm not exactly sure it's the penalty of paying for that. It's more of the, I was pulled over, there's other issues and different things like that. And to equate a seatbelt to leaving a firearm not secure, I don't think that's one and the same by any stretch of the imagination. So I would love to see how data was able to create some form of an education of the lay person to understand this is a bad behavior to correct. To me, increasing the penalty is not going to do that.
Well, I do.
And the stacking of the charges, that's all after the horse has left the barn. Those are all those issues. It doesn't speak to how you're going to educate people to make sure that they need to store their firearms.
So I'm going to say two things to that. So first, earlier in my testimony, I said it's about two things, deterrence and consequences. So it is about consequences as well. But also, I fully agree with you about education. We can't ignore the fact that people are allowed to have firearms and there isn't appropriate education. That has to be out there, but that's not this bill in front of us. I do believe that that's necessary as well. I believe they're both necessary.
Okay, thank you.
Sure.
For the prosecutor, Professor, you had mentioned research. Is it possible to share that research that you have with the committee?
I can gather that and send it to the committee, of course.
Thank you.
Okay. Further questions from the committee? Okay. Seeing none, thank you all very much.
Thank you, Mr. Chair.
Thanks. All right. That'll conclude the testimony for the proponents of the bill. Now switch to the opposition panel. And we'll, Mark Pennick, is Mark Pennick here? Do not see Mark here. We'll switch to our guest joining us virtually, former Senator Jill Carter, and former member of this committee. Welcome back.
Good afternoon, Chairman Smith and members of the committee. It's a pleasure to see you again, even though I have apparently a really bad video. So I hope that you have read my written testimony because I took a lot of time to lay out both the history and also the lack of efficacy for this bill. I feel very strongly about this issue because I was emotionally invested in legislating in a smart and intelligent way, in a way that supported both the Nikayla Strader family goals as well as made good policy for Maryland. If they are still there, I want to acknowledge Ms. McCray and Minister Ballone and Mr. Jarvis and whoever else may be there from the family. I understand that we aren't only legislating in the wake of the tragedy of Nikayla Strader, but trying to help save and prevent these traumas from other families and other children from falling victim to the type of acts that Nikayla did. But in so doing, we can't be sloppy, we can't be messy, and we have to be intelligent. Now, Senator Smith, I was there with the whole conversation over Jalen's Law, and it's interesting because one of the members, Senator West, was particularly opposed to my prior legislation because he felt, even though mine was more narrowly tailored to a death, that reckless endangerment encompassed this issue. I understand everything that the state's attorney said. My time is running out, but here's what you all need to know and you need to consider. While the state's attorney argues that she had a difficult time getting conviction under reckless endangerment, the truth is she got no conviction under 4104. I contacted the court. It had nothing to do with it being a low penalty. It was all to do with insufficient evidence. The statute as written is not conducive to enhancing a criminal penalty. It is conducive to exactly what was passed with the fine for the reason that we don't have a universal storage criterion, meaning that you're not being clear to people what they must do and then potentially enhancing the penalty. If you look at the fiscal note, as I did, you can see that very few convictions occur under 4104. Thus, enhancing the penalty won't change that. It won't make it better. My suggestion to this committee is to please consider, if you're going to pass something around this, and it's always going to involve children, it should be something that includes a program that helps these children overcome this trauma, whatever it is, whether they've discharged the gun, whether they've hurt themselves or someone else. We must deal with the child in helping them overcome the trauma. Number two, we must hold adults accountable, but any enhancement of criminal penalties must be narrowly tailored to harm and also behavior. There is a difference, as we recognize in all law, between negligence, gross negligence, and recklessness. And when the worst case scenarios can happen, we have reckless endangerment and we have involuntary manslaughter. Another similar statute we have is generally reckless driving, where we have a very low penalty for reckless driving, but when reckless driving results in harm, it can be greatly enhanced. I'm asking this committee to please, first of all, move unfavorable on this bill. For all the reasons I stated in my written testimony, I don't think it's a good bill, but also, if it's going to bear the name Nikayla Strotter, it ought to be something deeply meaningful and helpful to other children in Maryland. Thank you very much.
All right, thank you very much, Senator Carter. Questions from the committee? Senator West.
Quickly, Mr. Chair, Senator Carter, former Senator Carter, it sure is a pleasure to see you again. Thanks for coming. Thanks for taking the interest in this bill, and so much interest that you took your time to testify. I appreciate it.
Thank you, Senator West.
All right. Excellent. Hey, good to see you, Senator. Thank you for taking the time. It looks like there are no questions, and Mr. Pennick is not here, so that concludes the hearing and the testimony for Senate Bill 362. Thank you very much.
Thank you.
All right. So next is Senator James. Ready to go? Excellent. Senator James with Senate Bill 465.
Just because I'm not sure where I am right now, I am going to probably just read my testimony. So, and if you don't mind, I'd like to be joined by two people you know, Debbie Feinstein and Joyce King, that you all know very well. So, this is 7 little words that would mean a lot, especially in the area of domestic violence. Chairman Smith, Vice Chairman, members of the Judicial Proceedings Committee. For the record, Senator Mary Delaney James from Harford County. I want to thank the committee. You've seen this bill before. It's not been changed, and you've been very supportive. Now we have a House sponsor, and I'm hoping I will not be back here again, but I will if I need to. Senate Bill 465 adds second-degree assault to the statute that allows prosecutors to introduce statements in a criminal trial when the witness is unavailable and when that unavailability was caused by the wrongdoing of a criminal defendant. The statute to be amended is called the unavailability of declarants of statements due to wrongdoing. The reference to where that rule is in my testimony. And it's substantially similar to the Federal Rule of Evidence 8-804. Both codify a doctrine called forfeiture against wrongdoing, which stands for a pretty simple proposition that I think is so common sense that most people would understand it. It stands for proposition that although an accused defendant in general does have a right to confront a witness against, for cross-examination, a court will not suffer a party to profit by his or her wrongdoing. They will not allow a witness to be unavailable in court because of the wrongdoing of the defendant. This has been recognized in 2 Supreme Court cases, and they're in there as well. And while this concept of forfeiture against wrongdoing is recognized in all 50 states by common law or rule or statute, Maryland is the only jurisdiction that I could find that makes a distinction between felonies and misdemeanors. In other words, whatever the crime is, the defendant should never profit from making a witness unavailable at trial, no matter what the crime may be. But be that as it may, that we have this distinction, we also have an outlier because we are a state that treats second-degree assault, which is a very serious crime, as a misdemeanor. So this mislabeling has created this loophole that defendants in Maryland are quite well aware of. They know that they are not under this forfeiture against wrongdoing. Imagine that a battered woman is brave enough and courageous enough to go to the police, and she gives a full-throated statement with great detail about her abuse and who has been causing it. But because there's time between that statement and the court trial, the defendant gets to wear this person down over and over again through intimidation, coercion, whatever it may be. And then sadly and tragically, and this happens in Maryland, the woman never comes to trial to be the key witness against the defendant. If you pass this bill, we can stop this loophole, we can stop this practice, and we can give more protections for women who are abused. And that's my testimony. Thanks.
Good afternoon, Chair Smith, members of the committee. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I also have the privilege of co-chairing, along with my colleague, Deputy State's Attorney Joyce King, the Maryland State's Attorneys Association Special Victims Legislative Subcommittee. This has been a priority bill for our committee the last several years. You may recall testimony on this bill in last year and the year before, and I want to say a special thank you to Senator James for her perseverance. To me, this is a no-brainer, that someone can perpetrate a wrongdoing, can convince a victim not to come forward, not to come to court, and then benefit from that wrongdoing doesn't make any sense in the law. The distinction that Maryland makes between felonies and misdemeanors, as Senator James indicated, is unlike what any other state does. I'll tell you that within the last 2 weeks, I've had at least one case come before me where my prosecutor said, I have jail calls where the defendant is threatening the victim about coming to court. She, he, they does not want to come to court as a result. If she chooses not to come to court, we can't use forfeiture by wrongdoing. We can't bring the testimony of that victim that was made pre-trial to the finder of fact. Why the defendant should be able to benefit from that direct perpetration of wrongdoing really doesn't make any sense in our law. We're asking for a small change. Frankly, this should be a change. It should be admissible in all misdemeanor cases, but we're starting small with second-degree assault with the hopes that it's going to impact many domestic violence cases. Very quickly, I had the opportunity to hear the Public Defender's Office testify in opposition yesterday at the House hearing. They talked about the Confrontation Clause. There's already Supreme Court law that addresses this exact issue. It has not been determined to be a constitutional problem or a violation of the Confrontation Clause. They also indicated that this will bring about more jury trial prayers. And I see my time is concluded. I would urge support. I'm happy to answer additional questions with respect to the opposition or anything else. Thank you.
Good afternoon, Mr. Chair, committee members. My name is Joyce King. I'm Deputy State's Attorney for Frederick County. My testimony today is very much a me too. Didn't here to support on behalf of the Maryland State's Attorneys Association, but in particularly with the Frederick County Domestic Violence Coordinating Council. We submitted written testimony in previous years, and I don't want to belabor this because you all have heard a lot of this testimony for the last 3 years, but just to expand beyond domestic violence, that these cases, this application of forfeiture by wrongdoing also applies to several gang cases, and the necessity of getting evidence into trial when we have perpetrators purposefully silencing witness and victims to not come to court is a great injustice. And while second-degree assault in this case, we often think in the sphere of intimate partner violence, which is important, but it also extends to violent crimes and gang members that are utilizing this as well. So I did want to highlight that for the committee.
All right, excellent. Thank you all for your testimony. We have a question from Senator Love.
Thank you, Ms. Chair. Debbie, did you want to finish? I appreciate you respecting our 2 minutes, but I wanted to give you the opportunity to finish what you were going to say.
Thank you so much, Senator Love. Appreciate that. Some of the other things that the Public Defender's Office raised yesterday was that if this law passes, it will encourage or increase jury trial prayers from the district court to the circuit court, meaning that the case comes up on a docket, whether it's a gang case or a domestic violence case or any case in district court that's charged as an assault second degree, and then the defendant in every case in district court that carries a penalty of over, I think it's over 90 days, as long as there's a penalty of over 90 days, they always have that option. It's not a scary thing. They also have the automatic right to appeal from district court cases. I'm not sure what the big deal is about that, and so we'll try the case as a jury trial instead. We often have to do that anyway, because if the defendant gets a guilty conviction in district court, they have the automatic right to appeal. So in fact, it might be saving the citizens of our state time. They also indicated that They also indicated that oftentimes stalking cases come in on citizen-generated complaints. Absolutely, and those cases need to be investigated, but it doesn't change the fact that we would have to show evidence of the wrongdoing. We can't just assert that the defendant or perpetrator did a wrongdoing. We have to prove it, and it's most often proven either by live testimony or by a jail call. Frankly, that's really where we hear most of the wrongdoing being perpetrated, is someone calling. We've also found it on social media, texts, emails, that sort of thing, but we have to have proof of the perpetration of the wrongdoing. It's not like we can just pull something out of the air. This is obviously an exception to the hearsay rule. The confrontation clause is an incredibly important constitutional protection for defendants, but under these specific circumstances, the Supreme Court has said, and we do it in felonies, has said that this is an exception. Thank you.
All right, thank you all very much. Thank you. With that will conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. We have, is Ms. DeFore here? If not, we have Tamara Stofa joining us virtually. Welcome, you're up.
Oh, good afternoon. Thank you, Mr. Chairman. I'm asking for an unfavorable report of Senate Bill 465. My name is Tamara Stofa. I'm the District Public Defender for District 3 of the Upper Eastern Shore. As I've stated in the past, the right to confront and cross-examine your accuser is guaranteed in criminal cases by the Sixth Amendment of the United States Constitution, as well as the Maryland Declaration of Rights. To confront your accuser is fundamental to a fair trial. It allows the trier of fact to assess the credibility as well as the reliability of witnesses. It protects against the false accusations and wrongful convictions. In 2005, 10-901 of the Courts and Judicial Proceedings was created to allow hearsay exceptions in felony cases, cases that involve gangs, cases that involve violent crimes, as was mentioned by the previous prosecutor that testified. These cases are heard often in the circuit court. The current law creates exceptions that protects the trier of fact from hearing about any witness intimidation and allows the defendant to be tried simply on the underlying charges. Second-degree assault charges are misdemeanor charges. They're general intent. They are probably one of the most charged crimes that we get. They can be generated by citizen complaints. They certainly don't require domestic violence to be part of it in order to be charged with a second-degree assault. When it comes to these charges, allowing in this evidence, the standard is by a preponderance of evidence, which is more likely than not a very low standard. I do think that these cases would generate many jury trial prayers. The resources that we have in all throughout the state are not the same for the Public Defender's Office, and that would be important to take into consideration. We have one county judges, what that would do to these counties and getting cases through the administration of justice. I would also remind this court that you have an intimidation of a witness charge that could apply in these particular cases.
Thank you very much, Ms. Stofa. Questions from the committee for Ms. Stofa? All right, seeing none, thank you very much.
Thank you.
With that, that will conclude the hearing for Senate Bill 465. We'll now move on to Senator Jennings here. Senator Jennings is on his way. So we'll hold tight until
Thank you.
all right. You know what time it is then.
No.
This is an oldie but goodie, but it's a good setup with the two back-to-back like this. All right, so the first one you're probably going to get. What type of socks do pirates wear? Argyle, that's right. All right. What's a pirate's favorite letter? You think it's R? You think it's R, but it's really the C. Oh, see, you set it up like that. All right. All right. Senator Jennings, you're.
Oh, sorry, I've been up at B&T.
There you go. Senator Jennings, welcome. Senate Bill 454.
Thank you, Mr. Chairman. Distinguished members of the committee. For the record, Senator J.B. Jennings for Senate Bill 454. This bill is a bill I put in for several years, and I'll give you the history behind it. This goes back to a tragedy that took place in 2018 in Southern Maryland, the Great Mills High School, with a shooting at that high school that unfortunately killed 2 students, one the shooter and one his girlfriend that he went after. After that shooting, that tragedy, the legislature, a bunch of us met. I remember speaking directly with President Miller that morning afterwards saying we have to do something. And the thought was we have to come up with, a more robust school resource officer program. Legislation was introduced. We passed it. It was called the bear with me here. The Safe Learn Act of 2018. With that legislation, the idea again was putting school resource officers in all the schools. Starting at high schools, working our way to middle schools, and eventually elementary schools. The thought never crossed our minds that some jurisdictions would say, hey, we want school resource officers, but we don't want them to have their firearm with them when they are in the school. And unfortunately, some jurisdictions have decided to do that. And these resource officers, they are police officers. They are there for safety. They're not there to do any type of policing in the school. That's what a principal does. They're there strictly for, God forbid, something happened where somebody come in and want to harm a child. They're there to protect those children, those teachers, administrators, and all the other individuals in that school system. They have their service weapon there as a tool to protect them and disarm and neutralize whatever threat is there. So what this bill does, as you can see, it's pretty simple. It's a simple one line that says that a school resource officer shall carry a firearm while present on the premise of the school to which the officer is assigned. That's all it does. It's making sure that we have our school resource officers, when they are doing their job, they are armed so that they can protect those that they are there to protect. I'm not getting into what jurisdictions do this and doesn't do it. It's just, it was a state program that we adopted in 2018 to do this. And we want to make sure that if we're doing that program statewide, that those officers are armed and can protect everybody the way that they need to. I say that because, down here we do our jobs. We are protected by officers every day. We do have a trooper sitting here in our corner of this committee room protecting us. And we know there's nothing we love more than our children, and we want to make sure that they are safe in their schools. And that is why I put this in every year, and I work very hard to try to get it passed, because to me this is very important, and I ask for a favorable consideration, Mr. Chairman.
Good afternoon, Mr. Chair, members of the committee. My name is Clyde Boatwright, President of Maryland State Fraternal Order Police. I have the unique opportunity to speak to you as a historian on this particular topic because my day job is as a school police sergeant for Baltimore City. I was fortunate enough to be president of Maryland State FOP that represents 21,000, but it's the 100 officers of the Baltimore City School Police that I represent on a daily basis. It's important to understand the history of this. We have data that suggested after 9/11, Baltimore City schools were considered soft targets, and so the chief of police was given the discretion to allow police officers to be armed. 2 years later, I was employed by Baltimore City School Police in 2003, and this law existed prohibiting school police officers from carrying firearms, but it never impacted me because of the ruling given by the chief of police at the time. Fast forward to 2015, there was a parent who did some research and brought it up to the school board that school police officers were prohibited from carrying firearms during the school day, and hence our officers started storing their firearms in a safe for the instructional day. So as it works out, 8 o'clock in the morning during the intake, the school police officer is in uniform and is armed. Once the instructional bell rings, school-based officers are to go to a safe and store their firearm until they either leave for lunch or until dismissal. As we can see, school shootings are not a thing that's unique to just our jurisdiction. I mean, we had one in Montgomery County on Monday. We had one in Canada yesterday. So it's a worldwide phenomenon right now. And police officers having the tools, the best tools available to them at all times to to stop a school mass casualty incident is one thing that we urge, one reason why we urge a favorable report.
All right, thank you very much, Mr. Boatwright. Senator, you have a couple other people signed up in support of this bill. So I'm looking for, is John Jocelyn here or Jeffrey Shorter? I know they're both going back and forth. What about John Williams? I know there's a lot going on today. All right, so then we'll just turn it over to the committee for questions for the panelists that have testified in favor of the bill. Senator West.
Thank you, Mr. Chair. I just have one question. The opponents seem to feel that having an SRO in a school carry a firearm would make it more dangerous. Is there any, Mr. Boatwright, you probably would be the best to answer this. Is there any record of SRO officers carrying guns where somehow the gun got taken away from them and used in a school to harm someone?
No, in fact, in our profession, we have safety equipment called a triple threat holster, where it takes almost an algorithm to get the firearm out. It has to be at a certain angle for the firearm to be removed from the holster. So someone cannot run behind me and pull backwards and extract the firearm from my holster. It can't happen that way. I have to snap, pull, twist, lift all at the same time to get it out.
So you can say with confidence that having an SRO with a firearm in a school would not detract from safety in the school?
No.
Thank you.
And there, to add to your question, there are 24 jurisdictions in Maryland and 23 have police officers that are armed all day during the school day.
Just so I caught that, so there, in the state of Maryland, since we passed that initial 2018 law, 23 of the jurisdictions do have law enforcement police officers in the schools. Is that correct? Every day?
Yeah, all 24 have police officers in schools all day. And then it's 23 that are armed all day.
Okay, so what I'm trying to understand is, I believe this was in response to dealing with threats of people that overwhelmingly are carrying guns. I'm sure there's threats that can come from other knives and things like that, but I'm assuming that a vast majority of the things we read about are perpetrated by people that come to schools with firearms.
Yes.
Okay. So what would a police officer, I'm struggling to understand what a police officer could do without a firearm when confronting the vast number of people that are threatening schools are coming with firearms. What would you be able to do, if anything, in response to that, and quickly to certainly suppress the threat?
Yeah, so we're trained to address the threat with our firearms.
Right.
However, unfortunately, if your firearm is in a safe,
Right.
and I responded to a school shooting at Douglas High School where the school-based officer, where a staff member was shot in front of the main office, and the staff member tussled with the gunman while the school-based officer had to run to go get his gun. Thankfully, there were two other officers that were there at the building that got into the fight with the gentleman who was shot 3 times to disarm the suspect and take him into custody.
People there, I would say.
Yeah. It just so happened they had a parent conference and the supervisors were in the conference when the shots rang out. So what a police officer has to do is he has to get to the safe and then get back to address the threat. And if you know some of the size of some of our schools, if the threat is in the gym and you're in the cafeteria and your firearm is in the safe on the second floor, you got to run to the second floor, go retrieve your firearm, and then make it all the way to the gym.
Well, let me just, would the protocol be under those in that circumstance? There was fortunately other law enforcement. If you're a single law enforcement officer in a school that has your gun in a safe, then what would the training be? Would it be, don't stop the gunman, run to get your gun,
Yes.
come back? So, but
Yeah, so you're ordered by
you're not
policy.
going to go wrestle with him without your gun. So the gunman comes into the school property, and basically, if you're not going to wrestle him, you probably get shot if you do, but basically gets to run around shooting at people until the police can run up, get the gun, and come back and then find the gunman. That would be what the training says.
Yes, ma'am. The policy says that you're required to intervene and to go and retrieve your firearm from the safe and then try to engage the suspect.
And the reason I didn't ask some of this to inform me, but we also have this incredibly terrible Uvalde shooting situation. And, you know, people are of different minds, but we're demanding, and we expect our police officers to do everything in their power to protect students.
Yes.
So kind of difficult to do when you're running up to go retrieve a firearm.
In fact, one of the officers from Uvalde was charged for his cowardice for not acting in an official capacity.
It's a very intense. All right, thank you.
Yes.
Thank you very much. I think I remember a number of years ago when this bill was brought before the sponsor. Is the bill any different than what it was when you first introduced it? And the sole reason I'm asking, I think this is the first time that I've seen it in this committee. It's usually in EEE. So, I mean, is the language changed at all that got it out of there to here?
The issue with the bill prior was every school system refers to their SROs fall under their police department's school system, or I mean, their police department's agency. One jurisdiction does not. Theirs is an actual separate police department. So the bill would call them out. And basically what we did was craft it so we're not trying to single out one independent jurisdiction in the bill. I'm not trying to make this political. I'm not trying to make a statement with it. I'm just trying to deal with the issue. That's why, that's the difference in this bill from prior years, and I think why it ended up in this committee versus other.
Okay, and for Mr. Boatwright, two questions. One, and I know the sponsor says he's not trying to call out any particular jurisdiction, but I know we're talking about Baltimore City. The Baltimore City Public Schools, they said, and I would like to give you an opportunity to respond, that the Baltimore City Board of School Commissioners finds that this bill is a local bill and it only impacts Baltimore City Public School System. Therefore, the issue should be left between the Baltimore City Public School Board and its Baltimore City delegation. Do you have a response to that?
Well, so now I will be switching roles to the state FOP role and not particularly representing. So I do want to ensure that my other members around the state of Maryland are not impacted if a local jurisdiction then attempts to tell the sheriff or the police chief that their officers cannot be armed. And so, yes, does it impact me at home with the city school police? Yes. But this could, expand to any of the other jurisdictions across the state. And I don't know if a chief or a sheriff would listen to that, or would they just pull the officers out, and now we have students that are unsafe.
And I appreciate, I want you to keep that hat on, because I have one more question for you.
Yes, sir.
Anywhere else in the code, because on page 3, lines 4 and 5, it says a school resource officer shall carry a firearm while present on the premises. Is there anywhere else in the code where we tell law enforcement that they shall carry? And I'm asking because I don't know.
No, but under the education code and the creation of the Baltimore City School Police, it specifically prohibits school police officers that are school-based from carrying firearms.
And if it's a mandatory duty, if we were to pass this and there's an officer, a school resource officer on the premises and doesn't have their gun, I'm assuming that would be some sort of a violation that their department could probably penalize them for?
I don't know if the officer could be penalized because, they would be following the agency policy at that point.
I'm saying, all right, we passed this. This is now the law of the land. a SRO doesn't have his or her weapon while they're on premises, I'm assuming they would be disciplined for that because it's now they're mandated to carry these, right?
That's correct.
Okay. Thank you.
And just so you understand, if I call for assistance, if I'm a school-based officer and I call for assistance for a large fight at a walk-up school in the community, and we have Baltimore City Sheriff's Office, Baltimore City Police come into my building, they're not required to stop at an office and put their firearms and store them in a safe. But if I'm a school-based officer, I'm on the scene dealing with this critical incident with an empty holster. For context.
Thank you very much. Just two quick questions. One is, what is the training that SROs receive? It's different, right? Is it different or is it specialized? What is the training receive? That's one. And then two is, if you changed it to a may instead of a shall, that would basically relegate that decision-making to like the policies of each jurisdiction. Is that right? Or is that your understanding?
Yes to both. SROs across the state of Maryland are required to take Maryland Center for School Safety SRO training every year, which is in addition to the standardized in-service training that we must take based on Maryland Police Training Standards Commission. So as an SRO, you receive that additional training to learn how to de-escalate and other things, mindfulness. And there's a very, very robust curriculum that SROs, particularly those that are in schools, are required to take, and that's for all school safety personnel. And your second question was if it was to turn to May. I think May would be a huge step in the right direction, giving each jurisdiction the ability to make that determination on their own. That's a huge step in the right direction. I like that as an amendment now, Mr. Chair.
So, school resource officers in Baltimore City or wherever, you attend a police academy?
Yes, sir.
What police academy do they attend?
Baltimore Police, or whoever has open slots.
So it's the same police academy that every other Maryland officer attends?
Yes.
They just are then, once they're assigned to a school, if they're assigned to a school, they're just attend and receive additional training, specializing more in like interaction with kids and the policing of a school, that type of environment, right?
Yes.
They have that additional, but they still maintain their police certification through MPTC annually, you said?
Yes.
And they continue to enhance their training on the in-school environmental as you know, the process of policing in our schools evolves. They stay up to date on the newest tactics and policies and procedures.
Yes, sir.
Okay, thank you.
All right. Further questions from the committee? Seeing none, thank you both very much. Thank you.
Thank you. Thank you.
So that will complete the testimony for the proponents of the bill. We have one guest joining us virtually who is in opposition, Ms. Chaudhry. Welcome, you're up.
Oh, hi. Can you hear me okay?
We can, yes.
Okay, great. Thank you. Good afternoon, Chair Smith, members of the committee. On behalf of CARE's office in Maryland, I respectfully urge you to oppose Senate Bill 454. We all agree on one thing. All of our children deserve to be safe at school. But this bill unfortunately takes a one-size-fits-all approach by mandating that SROs carry firearms at all times on school grounds. It removes the ability of local school leaders, educators, parents, and communities to decide what safety looks like in their own schools. And the reality is that every school community is different. What works in one district may not work in another. I was born and raised in Baltimore City, and I know the circumstances there are very different than, for example, Anne Arundel County or Harford County. And this bill overrides local judgment, and it replaces it with a statewide mandate. Many students, especially Black, Latino, immigrant, and refugee students, already feel anxiety around law enforcement due to experiences with profiling or over-policing. And requiring firearms in schools risks increasing fear rather than safety. Schools should feel like places of trust, growth, and support, not places where children feel surveilled or criminalized. And the reality is that research does not clearly show that armed officers can prevent school shootings. What safety experts consistently point to instead are comprehensive strategies, strong mental health services, threat assessment teams, violence prevention programs, and positive school climates. Prevention and early intervention do work, and this is substantiated by data and research. Mandating firearms also unfortunately increases the risk of escalation during routine school situations. discipline issues, misunderstandings, or moments involving students with disabilities. Across the country, we already see disproportionate discipline and arrest rates for students of color and students with disabilities. Expanding armed presence risks deepening those disparities. Maryland has made progress in training SROs in de-escalation and bias awareness. This bill is well-intentioned, and we understand the impetus for it, but unfortunately, it moves us away from that balanced approach and toward a policy that prioritizes weapons over prevention. If our goal is real safety, we must invest in strategies that reduce conflict, that build trust, and that address root causes. Thank you for your consideration.
Thank you very much, Ms. Chaudhry. Questions from the committee? All right, seeing none, thank you very much. Is there anyone else that we've missed that's signed up to testify on behalf of this bill? Who's signed up unfavorably in person? I only ask because someone's trying to troll me over here, so I want to make sure. All right. I'm not going to say that name on camera. All right. That'll conclude the testimony for 454. We'll now move on to Vice Chair Waldstreicher with Senate Bill 365, and I believe a member of okay, Kara's going to testify. Excellent.
Good afternoon, Chair Smith and members of JPR. My name is Kara Venables, and I am Chief of Staff to Senator Waldstreicher. The Senator is under the weather, so I will be presenting his bill, SB 365, Security Guards Certification Renewal Requirements. The good news is this bill should be more straightforward than his bill that we heard last night. I'm a staffer and used to working behind the scenes, so if I'm wrong and you find it controversial, please don't roast me. We do have a former senator on the panel, so if you need to blow off some steam, he's volunteered to take the hot seat. SB 365 seeks to modernize and clarify the process of security guard certification. In years past, a hard copy of the application needed to be submitted to the Maryland State Police and processed. This took time, which is why a late fee was imposed if submitted in the 30-day window before the certification expiration. Now this process is completely digitized, and even if the renewal application is submitted at least a day before expiration, it does not create a burden. I would like to recognize the Maryland State Police who are here today for their willingness to engage on this issue. The state police and security guard industry worked closely to hammer out the language of this legislation. The bill as filed contained a drafting error that was corrected with a sponsor amendment. This amendment is available on your floor system and reflects the current wording agreed to by the Maryland State Police and the industry. Thank you for your time and consideration. I ask the chair and the committee for a favorable report.
Chair Smith, members of the committee, my name is Steve Amate, and I'm the Executive Director of the National Association of Security Companies, NASCO. NASCO is a trade association for the contract security industry, and our member companies employ thousands of licensed security guards in Maryland. I want to thank Senator Waldstreicher for introducing SB 365, a common-sense bill that will bring greater efficiency and clarity to the security guard certification renewal process, and NASCO urges the committee to pass SB 365. First, the bill will align the timing of security guard certification renewals to match that of all other certifications and permits issued by the state police. This benefits both certification holders and the state police. Second, to help prevent security guards from having their certifications expire and thus force them to stop working and require them to reapply for certification and retake the initial certification training, the bill requires the state police to send renewal notices to certification holders. Third, the bill eliminates unnecessary, confusing language in current law that states a guard seeking to renew their certification shall submit application at least 90 days before their certification expires, along with the renewal fee, and most confusingly, with the amount of any late fee. With online licensing, there's no need to submit renewals 3 months in advance, and more so, I think it's illogical that someone who submits an application 90 days before their certification expires, or even a day before expiration, could be subject to late fees. The above statutory language has created confusion among security agencies, guards, and the state police, and SB 365 eliminates the 90-day language as well as imposition of late fees. Finally, the bill eliminates an outdated and superfluous requirement that security guard employers submit a declaration 90 days before each of its guards are up for renewal to attest that the guard still qualifies to be certified. That is something that can only be definitively determined by the state police after it has conducted the fingerprint-based state and FBI check on the guard that is a requirement of renewal. Thank you.
You got it in. You landed the plane in 2 minutes. There you go. All right. That's good.
Mr. Chairman, I'll be brief. John Pica on behalf of National Association of Security Companies. I'd like to thank Ms. Dudley for her testimony. I'll just say this modernizes the process, going from paper to digital, and we support the amendment which removes the brackets on page 3, lines 28 and line 33. That's all I have, Mr. Chairman.
Excellent. Thank you both very much. Thank you to the Chief of Staff. Questions from the committee? I thought there was going to be some hazing going on here. All right, so no questions. Thank you all very much. Thank you.
Thank you.
Thank you. All right, with that, that will conclude the testimony in the hearing for Senate Bill 365. We'll now move on to Senator Sidnor, if you're ready to go. Oh, excellent. With Senate Bill 475.
Never mind. All right. I'm going to break this up a little bit from how I usually will provide my testimony. Then I'll go into my usual thing. I have a few lyrics here now. I want to ask you all to name that artist, okay? All right. I'm going to start off easy because this one has been in the news a little bit. Young ladies, I like them underage. See, some say that's statutory, but I say it's mandatory. No. Kid Rock. All right. When I was just a baby, my mama told me, son, always be a good boy, don't ever play with guns. But I shot a man in Reno just to watch him die. Folsom Prison Blues. Mama just killed a man, put a gun against his head, pulled my trigger, now he's dead. Queen, Bohemian Rhapsody. One more. Y'all doing pretty good. Good thing my daddy made me get a boating license when I was 15, and I've cleaned enough houses to know how to cover up a scene. No, nobody, no crime.
Can you sing it though?
I will not sing it. Do you know it? But you know, who is it? Any guesses? All right, the song is called Nobody, No Crime, Taylor Swift. All right, so now to the serious part. You a Swiftie? No. You're not? Oh, no, okay, I'm sorry. Across the United States, creative works such as music, lyrics, poetry, written narratives, visual art, and other forms of artistic expression have increasingly been introduced improperly as evidence in criminal proceedings. Research by the University of Richmond, Professor Eric Nielsen found that rap lyrics alone were used as evidence in approximately 500 criminal cases between 2009 and 2019, revealing a broader pattern in which artists' works are taken out of context and presented to juries as factual admissions of guilt. While rap lyrics are the most frequently cited examples, this practice extends across many forms of creative expression that are often fictional, metaphorical, and expressive rather than literal. As evident in 2 recent cases, Maryland is very much a part of this trend. In the Montague versus State, the Maryland Supreme Court upheld the admissions of a defendant's rap lyrics in a murder trial after concluding that the lyrics bore a close nexus to the details of an alleged crime and that the probative value of the lyrics was not outweighed by the danger of unfair prejudice. In Hannah v. State, the court found that the prosecutor had improperly cross-examined a defendant about rap lyrics he had written 2 years prior because it was done for the purpose of establishing the defendant's propensity for violence and thus unfairly prejudicial, entitling him to a new trial. The court also acknowledged that there was a certain circumstances where the lyrics possess an inherent and overriding probative purpose. One circumstance would be where the lyrics constitute an admission of guilt, and otherwise would include rebutting an offered defense and impeachment testimony. These cases demonstrate a clear tension in Maryland law. Although courts recognize the prejudicial nature of creative expression, judges are left to apply general evidentiary rules that were never designed to address the unique nature of artistic works and the always changing forms and language found in arts. This legislation is a strong effort to codify the common law test laid out by the Maryland Supreme Court in these 2 cases, addressing this gap by establishing clear, reasonable guardrails for when creative expression may be admitted as evidence in criminal and juvenile proceedings. Under this bill, a defendant's artistic work may only be admitted if the court determines that the defendant intended the creative work to be taken literally rather than figuratively or fictional expression, or that there's is a strong and specific connection between the creative work and the alleged offense, and the creative work is directly relevant to a disputed issue of fact. Importantly, this bill does not impose a blanket ban on the use of creative expression in court. Instead, it ensures that artistic works are admitted only when they genuinely serve the interest of justice and are not used to inflame jurors or reinforce harmful stereotypes. Without these protections, we risk criminalizing creativity and disproportionately impacting communities of color whose artistic traditions, particularly in hip-hop, are more frequently scrutinized, criminalized, and misunderstood. The music industry, civil liberties advocates, and the arts organizations strongly support these protections, recognizing that this issue extends beyond individual defendants. At stake are fundamental principles of free expression, due process, and the fairness of a criminal justice system. This legislation affirms that Maryland values both public safety and constitutional rights. It ensures that our courts rely on evidence of conduct, not creative imagination, when determining guilt or innocence. By adopting the PACE Act, we provide our judiciary with clear standards, protect artistic freedom, and uphold the integrity of Maryland's legal system. For the aforementioned reasons, and if you look at the sponsors on this bill, how often are you going to see a bill that had bipartisan support in the criminal context? I urge this committee to issue a favorable report. Thank you.
Good afternoon, Chair, Vice Chair, members of the committee. My name is David Wheaton. I am an attorney with the Legal Defense Fund. Founded in 1940 by Thurgood Marshall, LDF is the nation's oldest racial justice legal organization. We support SB 475 as an appropriate and effective effort to codify the test laid out in the Maryland Supreme Court in Montague v. State of Maryland, a decision evaluating the admissibility of rap lyrics in criminal cases. If enacted, the rule codified in SB 475 would protect First Amendment rights to free expression while also permitting prosecutors to omit the creative expression in a trial against the artist if there is a strong temporal and factual nexus between the crime and the creative expression. The bill ensures that artists' expression cannot be unfairly weaponized against individuals in court unless legal thresholds are met. For Black Marylanders, this legislation is particularly important. Maryland has a long-standing reputation for producing incredible Black artists, poets, dancers, and musicians whose work has galvanized national and global culture. However, in a legal system which disproportionately police and prosecute Black individuals, artistic expression, especially in rap music, has been wrongfully used as a means to criminalize Black voices. This bill is a step in preserving art and constitutional First Amendment protections while also allowing the admissibility of such evidence when warranted. We believe that this legislation helps codify existing standard and would help limit improper admission to the use of artistic expression as evidence in criminal proceedings. It is also imperative that we codify case law. Having a statutorily codified standard creates predictability rather than having courts figure out how to best address complaints on a case-by-case basis. We ask for a favorable report out of committee. Thank you.
Hi there. My name is Phil Wolotsky. I'm the executive director of an organization called Free Our Art. It's a coalition organization of creative organizations, including the Recording Academy, Recording Industry Association of America, PEN America, SAG-AFTRA, and many others. So we're in year 4 of this bill. I think you know it pretty well by now. I'd argue we've gone about this process the right way. We're proud to count both Senator Sidnor and Senator Charles, as well as Ranking Member West and Senator Motz as sponsors. And I would say, too, that there are not that many bills that come before this committee that are both supported by the NAACP, as well as the American Legislative Exchange Council. I'd also like to thank, too, State's Attorney Ivan Bates for his personal support of this bill. So I want to bring this down to what this bill is actually about. Codifying a Maryland Supreme Court decision and creating guardrails to prevent the already prohibited admission of character and propensity evidence in trials. If you'll indulge me, I want to bring you into a jury room and read you lyrics from an artist who's known as The Boss, and I'm going to read them as prosecutors do in courtrooms across America today. Me and her went for a ride, and 10 innocent people died. With a sawed-off 410 on my lap, I killed everything in my path. I can't say I'm sorry for the things we done. At least for a little while, me and her, we had us some fun. So why we're here today is to actually ask the question, under what circumstances should these be admitted in a criminal trial? The state's attorneys, broadly, are arguing for wider use. We're arguing for a law that reminds judges of existing law in Maryland. And frankly, it concerns me why the pushback is this assertive as it is, and what that indicates about current use of creative expression in Maryland. Because you may not care for the music of The Boss, who's better known as Bruce Springsteen, but unless he's charged with driving down a highway with a sawed-off 410, killing people, those lyrics should not be admitted. But across America, those types of lyrics are being incorporated today into trials and almost exclusively used against Black and brown boys and men. That's what this is about. Do laws apply to all of us or just some of us? Thank you.
All right, thank you all very much. Questions from the committee? Did you say Senator West was a co-sponsor? There you go.
Yes, he is.
There you go.
No questions.
Questions?
Thank you very much.
Thank you all very much. All right, we'll now hear, that'll conclude the testimony for the proponents of the bill. We'll now hear, yes.
Good afternoon.
Ms. Leitis.
Good afternoon. My name is Ann Colt-Leitis. I'm the elected state's attorney here in Anne Arundel County. Chairman, do I have a little bit more leeway with time because I'm the elected?
Yeah, you were not timed.
All right, thank you so much. I'm also here with State's Attorney Rich Gibson, who is to my right. He attempted to sign up for testimony but was unable to do so. The person who was originally going to testify, Ms. King, was not available. You heard lyrics from Senator Sidnor, and the first thing I'd like to say is those lyrics that he recited would not come into a court of law in Maryland. And the reason why is in the Montague case, that case set out when you can use lyrics or artistic expression, when you can show that there is a strong nexus between the artistic expression and the crime that's charged. And the reasoning in the Supreme Court was that it would be unfair, and they recognized it would be prejudicial to allow lyrics about general violence, gun use, glorifying violence, glorifying drug use against somebody simply to show that they were, quote, a bad person. So there are guardrails that are already in place. That's why this bill is opposed by 23 of the 24 elected state's attorneys in the state of Maryland. You did not hear in the proponents' recitations of the law, any case in Maryland where we went off those guardrails, where someone was convicted on simply saying lyrics like you heard about Taylor Swift and Bruce Springsteen. I respectfully oppose this legislation because it significantly alters the long-held evidentiary standards that are already in place, which dictate whether a judge should allow any evidence to go before the jury. And it's not preponderance of the evidence. It's a standard that every single piece of evidence in every single courthouse, in circuit court in particular, has to address. And that is whether the probative value, the tendency to prove a fact, is outweighed by any potential unfair prejudicial effect. And judges are the very gatekeepers that have to determine what evidence should a jury hear. It's the exact same standard. First, they have to decide, are these artistic expressions relevant to the facts of the case itself? Is it, in other words, is the juice worth the squeeze? Does it tend to prove a fact that is more likely true, or does it unfairly make the defendant look like a bad guy? The latter is forbidden evidence, and it will be excluded by the judge. Prosecutors cannot simply play videos or play songs recorded by a person and show them doing something wrong. That would unfairly prejudice the defendant. And I don't think you heard any cases today where that occurred. For every single type of evidence that comes in, there will be a pretrial hearing, and a judge would decide, will this evidence prove a fact in issue, and is the defendant's rights protected? It's not permissible to use evidence that shows a person has a bad character or uses bad language. Last month, I tried a murder case, and it's very interesting because this bill does not address what would happen if a defendant wanted to use this kind of evidence, artistic expression. And in my case, the defense attorney wanted to use a rap of a friend of the defendant's to show that he was the killer and not her client. And why it was relevant in particular is that that individual actually talked about Swiss cheesing somebody. The murder happened on one day, and a day or two later, the friend of the defendant was talking about Swiss cheesing and killing somebody. So under this proposed legislation, defense counsel would have been prohibited from entering that video into evidence because, one, it didn't speak to the specific facts of the crime, and it was not being offered by a defense against a defendant by the state, but by the defense against a third party. This evidentiary bill would change the long-held standard probative value versus prejudicial effect, which requires that weighing of the evidence that I spoke about. It would create a completely different standard only for artistic expression. So when you heard today that it would codify, it would actually change the law of evidence, but only for artistic expression. So preponderance of the evidence standard. I know of no other legal standard for using that standard for entering evidence in a case. And so the three prongs that are in this law, did the defendant mean it literally? Does it refer to the specific facts of the crime? And is it relevant to a disputed issue of fact? Are extremely difficult to prove. How would a judge exactly decide whether a defendant meant something literally or figuratively? How could anybody determine what was in the mind of the defendant? What happens if the defendant is retelling the murder that he committed in a haiku or a poem or as a story? Couldn't that be both literal and figurative? What if he's recounting the murder in an allegory recitation? When this occurs, a judge would be stepping into the role of the jury instead of allowing the jury to weigh the evidence, decide what it means, what it doesn't mean, and whether to give it any weight whatsoever. The next issue is the requirement that the expression refers to the specific facts of the case. In the Montague case, the strong nexus that was required had the judge actually examine all of the facts in the case. And what's important in Montague is that Montague actually made a jail call right before trial, and he sang a rap song describing the gun that he used, the car that the victim was driving, that he wanted to shoot or he could shoot a snitch, and the type of gun that was used, and the number of shots that were fired. So this was the determination that the judge made, that it was a strong nexus, and decided that probative value outweighed the prejudicial effect, especially because it was on the eve of trial. And Montague, at the end of his phone call, said, "What are they going to do with this? This is just a wrap." He knew he was being recorded when he made that statement, but he thought he'd be protected because he was singing essentially his confession, and he was not making it as a regular statement. I want to give an example of what could happen if this law is passed. Let's say an individual puts a video up on Instagram, or his friends put it up, and he sings about how much he hates the victim. But he doesn't talk about the crime. He doesn't show a particular weapon. Under this new legislation, that song could not come into evidence against him because he's not singing about the facts of the offense. It's excluded. However, under Maryland Rule 5-404B, a court can admit evidence of other crimes, wrongs, or acts if it is probative of these issues: motive, opportunity, intent, preparation, common scheme or plan, knowledge, identity, absence of mistake or accident. So with that same example of the video, what if the state's theory was that the victim was killed in a gang retaliation crime? And now the defendant is actively participating in the artistic expression, singing about how much he hates the victim or the victim's gang. Under the proposed legislation, that evidence will not come in because he's not talking about killing the victim or the specifics of the crime. He's just saying he hates the victim or the victim's gang. This legislation would say that this song is more protected because it's artistic expression, because it was a song or a video, than simply making that statement to another individual or perhaps writing it in a letter. But the fact of the matter is that defendants do not discuss their crimes in literal and factual manners. They are smart enough often not to recount their crimes in such specific details. But those details might prove motive. They might prove intent or common scheme and why a person is acting in a certain way. Last, the proposed legislation requires that the expression must be relevant to a disputed issue of fact. I can't tell you the number of times that I've been in court where a defense attorney will try and stipulate away certain facts so that I won't bring that evidence in. It happened last month. They wanted to stipulate away so I would not call the medical examiner because they did not want the jury to hear how the victim was shot in the head. So if there is not a disputed fact under this law, they could say, we don't dispute that the victim was shot. Therefore, you cannot use the video or the song or their artistic expression because it's not a disputed fact. The real world problem here is that defendants sometimes speak about their crimes in different ways. Some people, old-fashioned way, they write a letter and the letter gets intercepted, or it goes to a victim, or it goes to a witness who is intimidated, and that letter is turned over to law enforcement. Sometimes people make jail calls and they talk in vague, non-specific ways, but it can be interpreted as a threat. Sometimes they make Instagram posts, they make videos, they scribble notes on paper, and they write poems. But the central issue with this bill remains the same. It would require every judge to find that the expression refers to the specific facts of the alleged offense, with no wiggle room. For example, the state would not be able to introduce an Instagram photo of two defendants together simply to show that they knew each other. We couldn't introduce a creative selfie of the defendant that shows him wearing the same distinctive clothing seen on CCTV of the crime, same clothing as the perpetrator. We couldn't introduce a defendant's detailed writings about firearms to show that he knows how guns work, for example. We couldn't introduce a YouTube video showing the defendant dancing and handling a particular firearm to show that he possessed a firearm that has the same or similar appearance as the murder weapon. Individuals who engage in crime sometimes look for creative ways to get away with that crime being tied to them. Let's not give them a loophole. May I suggest that this rule or this legislation be referred to the Rules Committee, where you can make a pitch that if you're going to change the standard for admissibility of evidence, especially in creative ways, that be considered by them.
All right.
And I have one final thing, if I may, and I will be very, very quick. It's a poem by a person that was intercepted in jail, if I may. It illustrates my point. This is not just about rap lyrics. It's, yes. So beautiful, yet she does not know for her my whole world stops and my love will only grow. Her smile set my world ablaze. I see my whole life, my future, my everything in her gaze. My love for her is pure and true, but rip us apart is all the world, the law, and family want to do. She is mine, and I am hers. Forever and for always, our love endures. I am hers even in this time of despair. They rip us apart, hurting us and acting as if they care. My beautiful, my princess, my J, with you I chose to always stay. So when you decide to come back to me, know right here is where I'll always be. That is a 34-year-old man writing a poem about his 12-year-old rape victim.
All right.
I ask you or urge you not to grant a favorable report.
Excellent. Thank you very much.
Thank you
for that thorough testimony. Questions from the committee? Okay.
Thank you very much.
All right. With that, that will conclude the testimony and the hearing for Senate Bill 475. We'll now move on to Senator Muse, Senate Bill 464.
I have a panelist here. Thank you very much, Mr. Chairman and Vice Chairman, members of the committee. I have Christopher Dews, Zachary Alberts, Heather Warnton, and Megan McDermott. For the record, I'm C. Anthony Muse. I represent the 26th Legislative District, and I'm here to present Senate Bill 464, Commission to Examine the Expungement Laws in Maryland, which enables a commission to examine Maryland's expungement laws under Title 10, Subtitle 1 of the Criminal Procedure Article. First, the purpose is straightforward: to redesign the statute for greater efficiency and greater equity. It's been 10 years since the Justice Reinvestment Act created Maryland's current expungement statute. This law made a limited number of convictions eligible for expungement. Since then, the General Assembly has revisited this issue year after year to discuss, number one, which additional charges should be eligible. Number two, what conditions should apply. And number three, how the expungement process should work. This has prompted calls to update the statute entirely rather than take a piecemeal approach. This bill takes a deliberate and comprehensive approach. It creates a commission to, one, review the current expungement statute, two, identify inefficiencies and inequities, three, compare Maryland's law with other states, and then fourthly, develop thoughtful practice recommendations for reform. This goal is not a quick fix, but a clear, workable, and fair expungement framework. My panel will speak to the specifics of the bill and the proposed commission members. Senate Bill 464 is about getting this right and continuing to move us forward to a clear, coherent expungement framework. For these reasons, Mr. Chair, I respectfully urge a favorable report. The panel's here, and they'll go in the order that they choose.
Hi, for the record, Zach Alberts from the Center for Urban Families, here to testify in support of Senate Bill 464. I'm excited because MSAA and us are usually not testifying favorably for an expungement bill, so this is exciting. At the Center for Urban Families, we represent fathers and families who are looking to get back to work. Over 50% of them are justice impacted. And as you all know, time and time again, we see the effects of a criminal record on reducing recidivism or on increasing recidivism rates and the importance of expungement, reducing them and getting people back to work. of every 100 individuals we work with that come into one of our quarterly expungement clinics, only about 20 are able to actually get expungements because of the convoluted nature and sometimes self-contradictory nature of the expungement statute as it stands. Examples of expungible charges that seem strange off the cuff this year: discharging fireworks without a required permit, knowingly using a laser pointer to illuminate, harass, or endanger an individual in a public place. CR 5-709, possession of an inhalant for distribution. Note that PWID for other narcotics is expungible, but inhalants not. And then one trespassing on private property is expungible. CR 402, CR 403, which is effectively the same, is not. The current system is a hodgepodge of onesie, twosie additions over the years, as we hear from advocates and other impacted people who have compelling stories about why this specific charge should be added. It's a drain on y'all as a legislature, and it's a drain on us as folks that are trying to serve a broad range of clients who have a broad range of convictions. This is a smart way to address the issue. SB 464 would convene experts from across the political, government, and criminal justice sectors. Specifically, I'd like to note it includes both impacted individuals and representatives of crime victims. It's time to re-examine the expungement statute and bring relief to more people. We ask for a favorable report. Thank you.
Good afternoon, Mr. Chairman and committee. My name is Lauren Lipscomb, and I am the Chief of the Conviction Integrity Unit of the Baltimore City State's Attorney's Office, in which I've been a prosecutor for 20 years. I'm here today to provide testimony on behalf of the Baltimore City State's Attorney's Office, as well as State's Attorney Ivan Bates. We support Senate Bill 464 and urge a favorable report. Our reasons for support are twofold. First, the existing statutory construction is confusing and not user-friendly, even to prosecutors and judges. As Chief of the Conviction Integrity Unit in Baltimore City, I oversee all circuit court expungements, and I've managed expungements in various capacities since 2013. My unit is tasked with staying current on expungement law changes and reviewing petitions for eligibility. We have gotten to the point that one might need a degree in expungement law interpretation to accurately interpret the laws, given how confusing the language has become. Second, the sheer volume of expungements coming through the system is huge. A commission to study and identify areas to improve efficiency and support for local jurisdictions is welcomed. To be clear, since January 1st, 2026 to present day, Baltimore City has received 553 expungement petitions. These yielded approximately 184 cases on 2 separate dockets. We believe that Senate Bill 464 provides a good step forward in studying the overall statutory scheme and consideration of local concerns. In reviewing Senate Bill 464, we would also recommend that a stakeholder seat be included for the chiefs and sheriffs, as their agencies are directly impacted as well. We urge a favorable report on Senate Bill 464, and thank you very much for allowing me to testify.
Good afternoon to the committee. I'm Megan McDermott. I'm an advocacy director at Maryland Legal Aid. I started representing clients in expungement matters in 2017. Impacted people, advocates, and this committee have done a lot to advance expungement opportunities since that time. We added conviction eligibility to the statute. Then there came shielding of some dispositions. Then Maryland legalized cannabis. We went from 1 petition to 4. Then we added more eligible charges under the conviction list. It's a bit of a whirlwind just listening to that, and those are only a few of the changes. These important reforms have unintentionally created a process that is practically unnavigable for a pro se litigant. With some exceptions, people should be able to file expungements without an attorney. The process is form-based. The court's website has the forms posted, and they can be filed in person or online. But that said, as my colleagues have said, expungement is difficult even for attorneys to understand. I should know, I field calls from my colleagues at Maryland Legal Aid with questions all the time. Imagine how challenging this must be for someone without legal training, for someone who is under extreme pressure, because obtaining an expungement is critical to their employment or housing needs. At Maryland Legal Aid, we do our best to help. We assisted over 2,000 expungement clients in 2025. but there are simply not enough resources for the over 1 million Marylanders who have a criminal record and might be interested in expungement. The commission created by this bill would study the statute, identify the pain points, and look to best practices to make recommendations so the expungement process works as it should and is accessible to everyone, especially vulnerable and low-income Marylanders who have the most trouble accessing the court system. We urge a favorable report. Thank you.
All right. Thank you all very much. I know the senator's out of the room at the moment, but if we pass this bill, he's got to sit on this commission. So, all right, Senator West.
Actually, I was going to ask a question of the sponsor, but I guess since he's not there, maybe somebody else could answer my question. I'm looking at the direction to the commission. It has 3 elements. Element 1, examine the expungement laws. Element 2, review other states' expungement laws. And then 3, develop an alternative statutory scheme that provides a streamlined process and broader eligibility. That seems to me that sort of puts the rabbit in the hat. Would you think that would you agree with me that the bill might be better if the 3rd requirement was develop recommendations relating to possible improvements of Maryland's expungement laws, including the possibility of an alternative statutory scheme that provides a streamlined process and broader eligibility? Is there something? Oh, here's our sponsor. Sorry. Okay. Is there somebody on the panel who heard my whole question who thinks you could answer that?
Yeah, so I can take a first stab, but we also have other people on following panels that will have a perspective. I'll say from the advocacy side of a person that works in workforce development, right? We are open to conversations, as you can see, with the variety of folks that are put on the panel. I think there'll be some potentially contradictory views on expanding expungement eligibility. From our perspective, ideally the end goal is giving more Marylanders expungement relief. But I also know that when you look at the folks that are on the panel, there'll need to be some discussion about whether or not that's too narrow a definition.
I just think it sounds like a really narrow assignment. Your assignment literally is to develop a different statutory scheme. And you're going to have a lot of people with lots of different views on the commission. And my thought is you should look at recommendations to improve what we've got and maybe propose an alternative scheme.
Yeah, yep, very understandable. I would also say, as an advocate generally, commissions are anemic to my goals of progress. But because we understand that this is a very challenging topic that, has notions of justice, second chances, forgiveness, fairness, that we need to have a broad coalition. And so I think, I would defer to Senator Muse, but open for conversation, at least speaking for myself.
Thanks for your answers to my questions.
All right, seeing no questions for this panel, we'll bring up our next round of panelists. Thank you all very much. Mr. Dews, Sean Link, and Ms. Morgan.
Christopher Dews, representing Out for Justice. To your question, Senator West, that we will be open to that conversation. The reason why we talked about redesigning it altogether or a different statutory scheme is because of the feedback we've gotten actually in conversations with the State's Attorney's Office and with Office of the Public Defender and many others that it is just confusing. Like there's individuals who, one, trying to figure out if your charge is even eligible is one thing. Then how does that compare to shielding? Then there's, I think, 10-108, which goes into ex parte orders. And so, I've personally had to educate an attorney on the expungement statute, and so I think that the purpose of the alternative scheme is just to, if there is a day one rewrite that we can do as an update compared to what we had from 10 years ago, then that's the motivation behind that. However, I think we will be open to, if it is just improvement of the current statute, just trying to resolve that. And then also, as Zach mentioned from Center for Urban Families, very rarely do we have a bill that we're in favor with the State Attorney's Office on. We just know that this is something that does need to be looked at. As you all know, year after year, from the REDEEM Act to Abhishek from last year, there are just different conversations that need to be had around expungements. And so this bill actually came as a recommendation from the former chair of Judiciary quietly, and the majority leader who said, we keep taking a piecemeal approach. We should just take a step back. Oh, hi, good to see you too, microphone. Take a step back and just consider a redesign by bringing all the major players together. We thought this was a cost-effective and just effective way of having that conversation. So with that, I will take my seat. And I'm also happy to answer questions about who's on the commission and how it all got drafted. Thank you.
Good evening, Senator Smith, members of the committee. My name is Sean Link. I'm an attorney with the Maryland Office of the Public Defender, and we respectfully request that the committee issue a favorable report on SB 464.
Thank you.
Rehabilitation is a cornerstone of the criminal justice system, the belief that individuals can grow and change with the right resources. Expungement is rehabilitation in action, removing the stigma of a criminal contact off someone's record, whether they were falsely accused and found not guilty, or convicted but served their time, turned things around, and have now re-entered the community. According to the Clean Slate Maryland initiative, 22% of Maryland adults have some type of arrest record. Of these, fewer than half are currently eligible for a full record clearance today, yet only 2% of eligible folks have received expungement relief. This reveals at least two major issues: the limits of relief available for certain offenses and the vast number of folks who are not benefiting despite eligibility. Whether due to confusion, red tape, or lack of knowledge about their rights, there is a clear need to both broaden and streamline this process. So, while existing systems do benefit many individuals, OPD supports this commission, and I previously submitted written testimony further highlights three specific areas of concern: the obliteration of records, offense eligibility, and a personal right of access to one's own records, even following expungement. A few of my colleagues on the panel have already spoken about eligibility and confusion issues, so I'm going to focus briefly on obliteration. State law currently defines expungement as removal from public inspection by any of three possible methods: obliteration, removal to a separate secure area, or partial access. Unfortunately, many OPD clients who have successfully expunged their records find later that third-party background checks or factual federal records databases continue to incorrectly flag those cases as pending, and thus need a copy of the record to demonstrate what actually happened. For these reasons and for equity purposes, the Maryland Office of the Public Defender urges a favorable report. Thank you.
Good afternoon, Chair Smith, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in strong support of SB 464. I don't need to reiterate a lot of the important points that you've already heard from other panelists, but just to underscore the fact that a lot has changed in the past decade since the passage of the JRA, including growing recognition and documentation of the myriad collateral consequences faced by people living with a conviction, and, as you've heard a lot about today, the inconsistencies and the confusion of how to navigate our expungement system in Maryland. We've been working on these issues since the founding of our center in 2022, and can proudly say, in partnership with many of the expungement coalition members in this room and in this state, really important progress has happened as a result of this piecemeal approach. But with the more holistic and data-driven look that this commission is intended to provide, with the right diversity of perspectives around the table, we could do so much more. Our center does a lot of work really looking at convening across research, policy, and practice to take a more solutions-oriented approach. We see that is exactly what this bill represents, and this is an important opportunity for our state. So we urge a favorable report.
Excellent. Thank you very much. We have one more guest joining us virtually. Mr. Stephen McDonald, you're up. Welcome. Oh, sorry, Mr. McDonald. We're going to have to unmute you. Hold on one second here. Can you unmute yourself? There you go.
All righty. Thank you, members of the committee. My name's Stephen McDonald. I'm a resident of District 28 in Charles County and a member of Out for Justice. The testimony is submitted in support of Senate Bill 464. Maryland current expungement laws make it difficult for people to have completed their sentences to move forward, creating barriers long after the system involvement should have ended. My record is not eligible for expungement, not because of public safety concerns or ongoing involvement with the justice system, but because of technical statutory inconsistencies. Criminal Law 5601, including a misdemeanor for counterfeiting or altering a prescription, is eligible for expungement, while Section 5701D4, which criminalizes the same conduct, is not. These charges are functionally identical, yet treated differently under the statute. Because expungement eligibility has been added piece by piece without aligning laws that cover the same behavior, people like me are denied relief based solely on how a charge is labeled rather than the substance or severity of the conduct. I have completed my sentence and worked to move forward with my life, yet my record continues to create barriers of employment, housing, and stability. The expungement process is already difficult to navigate, but when the statute itself is internally inconsistent and becomes nearly impossible, relief exists for some but not for others who are similarly situated. And that inconsistency undermines both fairness and efficiency. I'm testifying because the problem cannot be fixed through small piecemeal changes. Senate Bill 464 takes that reality seriously by creating a commission to examine how Maryland expungement laws function and who they exclude, aligning statutes that criminalize the same conduct, basing eligibility on substance rather than technical distinctions would have made a real difference for me and many others. I respectfully urge a favorable report on Senate Bill 464 so Maryland can take a serious, thoughtful step forward in the expungement system that is fair, consistent, and accessible to those who have earned the opportunity to move forward. Thank you.
Thank you very much, Mr. McDonald. Questions from the committee? All right, seeing none, thank you all very much. With that, that'll conclude the testimony in the hearing for Senate Bill 464. Is Senator Guile in the House now? Oh, yeah, there you go. Yes.
I've got a few bills, Mr. Chair. Which one would you like to hear first?
Let's go for 397 first.
Okay, great. Sheriff Sasker up here. Good afternoon, or I guess nearly good evening, Mr. Chair, members of the committee. For the record, Senator Dawn Guile, Chair of the Anne Arundel County Senate Delegation, here to present Senate Bill 397. This bill, filed at the request of the Sheriff of Anne Arundel County, who is here with me today, directs him to appoint 3 majors at a salary determined by the County Council of Anne Arundel County. This legislation will assist the growth of the Sheriff's Office and provide improved community support. The existing selection process requires the Sheriff to select senior members of his executive command staff through a promotional process heavily influenced by the Fraternal Order of Police and not the needs of the community. Additionally, this limits the Sheriff's candidate pool, often excluding those who have the specific skills, knowledge, and experience necessary for these roles. The current system limits the Sheriff's ability to hold executive members accountable and address performance issues promptly. It also hinders the Sheriff's ability to diversify the executive command staff to better reflect the community. The current promotional structure often encourages groupthink and stifles innovation. Incorporating broader external experiences is necessary to prevent strategic stagnation and foster a more engaged workforce. This bill resolves these issues by authorizing and directing the Sheriff to appoint 3 majors. The legislation has the support of the Anne Arundel County Senators, and the letter of support has been submitted to the committee. And with that, Mr. Chair, I respectfully ask for a favorable report on Senate Bill 397.
Good evening, Mr. Chair, committee members. Thank you for having me here. I'm not going to belabor this. I think the senator put it well, Senator Guile. But I would like to also say that this bill is not a want, it is a need. It is needed to move the Sheriff's Office forward and to also better serve the community members of Anne Arundel County. As the way the current executive command staff operates right now, it is comprised of a captain and 1 lieutenant, 3 lieutenants, I'm sorry, who are part of the bargaining unit for FOP 106. When we discuss strategic things like dealing with personnel issues, I have to excuse the lieutenants because they are part of the bargaining unit, and sometimes they do represent some of the employees that we're discussing. Also dealing with issues regarding funding and things like that, I may have to excuse the lieutenants because at this very point, they are involved in negotiations with the county about our bargaining unit. And as the senator talked about or mentioned, the ability to find people from outside of the organization will also prevent groupthink. And it would also allow me to find people with strategic skills and mindset that will best accommodate the citizens of Anne Arundel County. So I'm here before you today, hoping and looking for a favorable on this particular legislation.
Excellent. Thank you very much. Questions from the committee? All right. Well, thank you very much. I saw, if you are a Senate page, you're welcome to come up on the side here to sit if you'd like. If you're a Senate page, come on up. You can sit on the side to get a better view of things. We'll even let the House pages come up too, so that's cool. All right. All right, with that, that'll conclude the hearing for Senate Bill 397. Thank you, Senator Guile. Thank you, Sheriff. We'll now move on to Senate Bill 406.
Okay. Great, I'm going to bring up my panel too, Mr. Chair. All right, I'll just jump in. For the record, Senator Don Guile, District 33, here to present Senate Bill 406. This bill is a narrow technical bill that corrects an unintended gap in Maryland law involving drug trafficking with a firearm. Maryland law already imposes enhanced penalties when someone possesses or uses a firearm during a drug trafficking crime. The issue is how drug trafficking crime is defined. Following changes enacted in 2023, certain cannabis trafficking offenses, like possession with intent to distribute, are now misdemeanors. As a result, when someone is found selling cannabis while armed, the firearm enhancement no longer applies, even though the same conduct involving another drug would trigger it. Senate Bill 406 fixes that inconsistency. The bill does not change cannabis policy, does not reclassify offenses, and does not create new penalties. It simply ensures that existing firearm enhancements apply consistently when drug trafficking activity of any kind is carried out with a firearm. The presence of a firearm in drug trafficking activity presents a serious public safety risk, regardless of the substance involved. And for these reasons, I respectfully request a favorable report on Senate Bill 406.
So we're going to take questions at the end of the panel, so thank you very much, Senator.
Thank you.
It's my first time in the Senate. Good afternoon, Mr. Chair. I'd like to thank you for this opportunity. My name is Lieutenant Chad Adkins from the Frederick County Sheriff's Office. I oversee my agency's narcotics unit, which participates in a HIDA initiative. I have over 2 decades of law enforcement experience where I've been heavily involved in drug enforcement. I've served as a patrol deputy, a canine handler, an assistant patrol operations commander, a federal task force officer, and now as the narcotics investigations section commander. I'm here today to voice my support for Senate Bill 406. When you dig into the core purpose of this bill, it's about one thing: protecting our communities from the dangerous combination of firearms being used while trafficking or selling narcotics. I can tell you from my current role as a narcotics commander, there is a black market for illegal marijuana, and this market is active, cash-heavy, and violent. These criminals know the weakness and inadvertent loopholes of our laws, and they have and will exploit them at any cost. I want to be clear, this legislation does not infringe on the rights of lawful gun owners engaged in lawful activities, nor does it infringe on the rights of legal cannabis users and the markets that follow the rules. This bill respects Maryland's intent with its legalization and decriminalization of marijuana. I'm a strong supporter of the Second Amendment, but having an HQL and a CCW license should not protect armed drug traffickers from prosecution. This legislation is common sense, in my opinion. It precisely targets the intersection where illegal drug sales and firearms present the greatest threat to our public safety. I'll be more than happy to provide recent examples where this bill could have been applied. I don't believe it was ever Maryland's intent to allow criminals selling drugs to be legally armed with firearms. It's our duty to protect our communities from this behavior. Today we have a chance to close an inadvertent loophole and send a clear message. If you decide to engage in illegal sales of narcotics, you don't get to arm yourself and endanger everyone around you. You'll be held accountable. Thank you for your time.
Good afternoon, Chairman Smith and members of the committee. My name is Moreau Williamson. I'm a prosecutor here in Anne Arundel County, Maryland. I've been a prosecutor for 18 years and assigned to the Felony Narcotics Unit the past 11. In that unit, I prosecute gun, drug, and homicide cases. I'm testifying today on behalf of the Maryland State Attorneys Association. The purpose of SB 406 is simple: to bring possession with the intent to distribute cannabis and manufacturing cannabis with the intent to sell back into the definition for drug trafficking with a firearm. Previously, these two crimes fell within the definition. However, they have both become misdemeanors in 2023, and a loophole has been created in the law. We are not talking about cannabis sold within the current regulatory framework. We're not talking about simple possession of cannabis. We are talking about people who sell drugs with a gun. Dealing or manufacturing firearms, cannabis with a firearm creates a dangerous situation, no matter what that substance being sold is. A gun in connection with a drug deal is just as deadly if someone's selling PCP, Suboxone, fentanyl, or cannabis. Last year in Montgomery County, the numbers showed in the previous 3 to 4 years, there were 18 homicides that occurred during the sale of cannabis. I myself have handled a homicide in which 2 separate firearms were fired on the seller side and the buyer side, and someone ended up dead over the sale of marijuana. Cannabis sold on the street remains a valuable and illegal commodity. The numbers speak for themselves. Cannabis is sold for $100 to $150 an ounce, and if you were to sell that by the pound, it could be sold for up to $2,400 to $3,200, depending on the quality. People will take measures to protect their stash. They will take measures to enforce debt. For that reason, we are asking that the crimes be reincorporated into the definition. We are not creating a new law. We are simply fixing a loophole. And I urge a favorable report on SB 406.
Good afternoon. My name is Jason Steinhardt, and I'm a prosecutor here in Anne Arundel County, and I'm here on behalf of the Maryland States Attorneys Association. I asked this committee for a favorable report for Senate Bill 406. When the General Assembly downgraded possession with intent to distribute cannabis to a misdemeanor, it created a significant loophole in Criminal Article 5621, which prohibits firearm possession with nexus to drug trafficking, but not for possession with intent to distribute cannabis. Illicit sales of cannabis are just that, a drug trafficking crime. Possession of a firearm in the context of illicit marijuana sales is no less dangerous than in the context of any other illicit drug. There may be a perception that cannabis is a less harmful drug, but the violence associated with the illicit cannabis trade is no different than any other drug. And yes, that includes cocaine and fentanyl. The reason why is because of the profit associated. When that occurs in the illicit market, that leads to violence. I know because I've seen that in the cases I've prosecuted. As one example, in 2023, I prosecuted a homicide right here in central Annapolis on Pleasant Street. The victim, Cornell Young, a 22-year-old young man who was here for purposes of cannabis sale, and this was a robbery over cannabis, and he was shot and killed right here in Annapolis. In July, I have another murder coming up from Pioneer City in Anne Arundel County, a robbery over cannabis gone bad. These laws exist for purposes of public safety. This keeps us safer. And for those who are concerned with overbreadth, the burden remains on the state to prove that such a firearm is carried with nexus to drug trafficking. This creates no presumption under the law. What I ask this committee to take away is that the real gravamen of this offense relates to the possession of the firearm itself, rather than the possession of a controlled dangerous substance. For those reasons, I ask for a favorable report. Thank you.
Good afternoon. My name is Jonathan Van Dyke, and I'm a sergeant with the Anne Arundel County Police Department. I've been a police officer for over 18 years, and during my tenure, I worked as a task force officer with the Drug Enforcement Administration, where I was also a narcotics canine handler for 10 of those years. Currently, I'm the supervisor of our Criminal Investigations Division Narcotics Squad. I'm testifying today on behalf of the Anne Arundel County Police Department. The purpose of Senate Bill 406 is to align the prosecution of intent to distribute cannabis with a firearm with the sale of other controlled dangerous substances with a firearm. Over the last 2 years, a total of 5,500 pounds of cannabis was seized from passengers traveling into BWI Airport. This is more than the weight of rhinoceros. Just on Friday, a total of 250 pounds of cannabis was seized at BWI Airport. These aren't personal use seizures. These are suitcases filled with heat-sealed bags and 1 to 2 pound increments of cannabis. And these are only the numbers of what was seized. This doesn't include the numbers of the cannabis that has made it through BWI. On the low end, the cannabis seized from BWI alone has a value of approximately $7.5 million. Typically on the West Coast, a pound of cannabis is purchased for around $600. Here in Maryland, when distributed illegally, a pound of wholesale cannabis can range from $1,500 to $2,000. My testimony isn't about people who use and possess cannabis within the current lawful regulations in the state of Maryland. This also isn't about the cannabis dispensaries that operate lawfully in the state of Maryland. My testimony is about the large sum of money and cannabis that is still being illegally trafficked into Maryland and the violence that is associated with it. I have personally witnessed a person shot at over 20 times because they were a large cannabis dealer. Fortunately, the 4 shooters didn't hit their target, and the subject, along with the shooters, were later arrested and charged by law enforcement. Last year, in Anne Arundel County, 20 people were arrested with possession with intent to distribute cannabis while possessing a firearm. These individuals were not able to be charged with a drug trafficking offense with a firearm. The value of the illegal cannabis being brought into and sold in Maryland caused firearms to be used and possessed in order for illegal cannabis dealers to protect their products and profits. We urge a favorable report. Thank you.
Good afternoon, Chair Smith and members of the committee. Thank you to Senator Guile for introducing this important legislation in the Senate. My name is Matias Cachero, and I'm the Deputy Director of Government Affairs for the Office of the State's Attorney for Baltimore City. I have submitted written testimony highlighting some arguments that have been iterated by other members of this panel. So for my oral testimony today, I want to focus on additional considerations for the committee. Since Maryland officially legalized recreational cannabis in 2023, the industry has made over $1 billion in sales and has generated over $73 million in tax revenue for the state. At the same time, it is important to acknowledge that cannabis prohibition in this country has long been intertwined with racial stereotyping and discriminatory enforcement practices. Legalization was intended in part to address those historic inequities and reduce unnecessary criminal justice involvement for low-level cannabis use. Senate Bill 406 does not reverse those gains, nor does it recriminalize recreational cannabis use. This bill is about addressing gun violence and holding accountable people who are not casual smokers or tokers. Individuals who operate outside the regulated market at a large scale and whose illicit activities directly linked to public safety risks, including gun violence. In my written testimony, I highlight a real case in Baltimore City where an individual was in possession of over 30 pounds of cannabis and over 8 firearms. And although the firearms were legally registered, the police investigation found that the cannabis and the firearms were in close enough proximity to each other to indicate that this individual was using these firearms in protection of a drug trafficking crime. However, misdemeanor charges or conspiracy to commit a misdemeanor violation of the statutes highlighted in this bill are not a part of the definition of drug trafficking crime, and that is what this bill seeks to address. This individual was only charged with CDS possession of cannabis. Thank you for your time, and I urge a favorable report on Senate Bill 406.
Excellent. Thank you very much. Are there questions from the committee? Smoking or toking? I like it. All right. Senator Henson.
Thank you, Mr. Chairman. Thank you to the bill sponsor for bringing the bill. I am reading some of the testimony, one of the ones from Maryland. I'm not familiar with the group name. Norm, I think it's pronounced N-O-R-M-L. Normal? Okay, the cannabis folks. Otherwise known as the cannabis folks. If I could ask anyone on the panel to respond to one of the points raised by them. In the testimony, it says, the bill also raises serious proportionality and fairness concerns. By attaching lengthy mandatory sentences to misdemeanor cannabis activity whenever a firearm is present, regardless of use or intent, it risks sweeping in lawful gun owners and imposing penalties far in excess of culpability. Could someone respond to that? Oh.
Thank you. So there's no presumption that this law creates that somebody who is in possession of a firearm is carrying that firearm with nexus to drug trafficking. That's something that the state has to prove. And this is actually in the Maryland pattern criminal jury instruction, that some of the factors that need to be taken into consideration, the location and proximity of that firearm to the drugs, whether it increased the likelihood of success of the crime, and whether it's within easy reach and available to the defendant. So again, it's fact specific. But possession, just as we have to prove that somebody possesses the drugs, we also have to prove that they are in possession of the firearm as well. So there are additional factors that we need to prove and that the jury needs to find. This is not just by default somebody who happens to carry marijuana and happens to carry the firearm is automatically in the breadth of the law.
So the two things, the possession of the firearm and then the possession of the marijuana, if they own the firearm legally and then they have the quantity of cannabis that's a misdemeanor offense, those two things could still equal felony under the bill.
I think the question is, I think what this organization might be getting at is personal use amounts of marijuana. This law would not apply whatsoever to personal use amounts of marijuana. This only applies to possession with intent or manufacturing for sale. This is aimed at drug dealers, not drug users.
I think the second category they're getting at as well is lawful gun owners. So if a person owns the firearm legally and then they want to sell the marijuana illegally, I think they're trying to get at the lawful gun owner, the illegal drug seller, and that person existing as one. So if you own the gun legally, but you have the unlawful quantity of cannabis, do those two things equal felony under the bill?
That would.
Okay.
That would. And just as if someone is selling cocaine and while owning a firearm legally, that would still be a felony. Something you brought up, which is interesting, distribution of cannabis is still a felony. So if someone is seen by police selling cannabis with a gun, they would still apply under this law. And I
think that's a little different, though, because the threshold here is different. This doesn't require you to be in the commission of selling. It's just the quantity that triggers the law here.
Correct.
So it is presumed that they're going to distribute if they have that amount. That's why we set it at that amount. But they could be a high-volume personal use person that just has an extraordinary quantity. I have a friend who has a large amount of shoes. Now, does she have enough shoes that if she wanted to be a person that sold shoes, she could? Yes. But no, she doesn't sell shoes. She just has a lot of shoes because she likes to have shoes for herself in an excess amount. So a person could have a lot of cannabis and they could be over the limit with which you could do that legally. We presume that if they're over that amount that they're doing it to sell. But the bill doesn't say that you have to be in the commission of a sale and have the firearm. It's just firearm plus quantity equal felony.
So in order to be found guilty of drug trafficking with a firearm in court, first someone has to be found guilty of possession with intent. If the jury finds the person guilty of that crime, then the jury moves on to the second question, are they guilty of possession with intent? So this bill is not changing the law whatsoever with what the state has to prove with possession with intent to distribute or to distribute with the intent to distribute cannabis or manufacturing with the intent to sell. This is literally just changing the definition and putting these crimes back into the definition. Prior to 2023, these crimes were part of the definition. And here's an example of the type of crime that this would normally apply to. So I had a case in 2023. I could not apply drug trafficking with a firearm because the law had changed. The person had about 15 pounds of marijuana in their house, $30,000 in cash, and a gun. So yes, that pointed to the person was possessing with intent to distribute. And someone is not going to just be found guilty on the fact that there's, a bunch of marijuana for personal use. There's going to be indications of selling such as money, scales, packaging, activity observed by the police, a very large quantity like 30 pounds. We have to have someone testify, a drug expert, based on their training, knowledge, experience, why they think this is indicative of possession with intent to distribute. And they have to go into that, and the jury has to think, is this person credible? So someone just having a whole bunch of marijuana or cannabis does not make them guilty with possession with intent. Just like if someone had a bunch of cocaine or a bunch of oxy pills, the state still has to prove that they possess that with the intent to distribute.
We do treat cocaine or oxycodone or other drugs different than we treat cannabis. We've made certain decisions, and when I say we, I mean the global we. We put it on the ballot for voters to decide if the recreational use of cannabis would be legalized in the state, and the voters decided to legalize a recreational amount. So the distinction that we're making here is over a certain quantity, you get from that recreational use into what is not legally permissible. And I'm trying to understand, this is over that amount in quantity plus the gun gets you to felony under the bill.
No, so there's no.
So there's several, just if you could explain just that for possession with intent to distribute, you have to have like a piece of volume, but then also other indicia. Like,
No, there's actually no.
Do you need bags? Do you need ledgers? Do you need other things that go to proving possession with intent? Possession of, let's say, under 50 pounds is, I think, our volume dealer. That's what you can charge for volume dealers over 50 pounds, sorry.
Right.
But let's say I have 20 pounds. That alone is not enough to prove possession with intent to distribute. 20 pounds with baggies and with like a ledger that it says, hey, like on December 4th, I did this, and with a scale. There's some other factors that go into proving possession with intent to distribute. It's not just the volume alone, is what I'm saying.
Correct. There needs to be an indicia of sale.
The word that I use, yes.
Yeah.
Thank you, Mr. Chair.
Questions from the committee? Awesome. Thank you all very much. Thank you. Do we have anyone else? Okay, so that, I think that's everyone for the proponents. Do we have anyone? So we have some folks signed up in opposition. Benjamin Charlton. Mr. Charlton, hold on. If we have pages, I said we have 2 pages. If you'd like to come up, sit up on this side, I know this side's full, but if you all want to come up and sit closer, you're welcome to do it. Up to you.
Thank you. Good afternoon, Chairman Smith, along with your fellow senators. Thank you all for allowing me to be here to testify. My name is Benjamin Charlton. I'm an assistant public defender with the Office of the Public Defender, and we are asking you all to give an unfavorable report on this bill for a number of different reasons. So with all apologies to Senator Smith, in order to prosecute somebody for possession with intent to distribute, volume alone is enough to charge somebody for possession with intent to distribute. And legally, it is enough if you had a bench trial for a judge to find a person guilty just based on amount. And those threshold amounts are a mere 1.5 ounces of loose leaf marijuana, 12 grams of vape oil, or 750 milligrams in total of edible marijuana, which you can buy up to those threshold amounts. So if you go on multiple days, any person is able to buy that much. So that is part of why we are opposed to that. The statutory scheme as well is enough. It already contemplates much of this, as Senator Henson pointed out before. The statutory scheme recognizes that marijuana is not the same as those other drugs, and that is why that was a misdemeanor. I think it's disingenuous to believe that all of you as senators did not understand that and understand its application to the gun trafficking statutes when making this type of behavior a misdemeanor. And many of the examples that were given by the proponents of this bill included violent crimes. When a violent crime is committed with a handgun, that is punishable with a 5-year mandatory minimum for use of a handgun in a crime of violence already. So there is already a mandatory minimum when handguns are used in these violent situations that were being described by the proponents. In addition, we would urge you all to consider something that was pointed out by one of the proponents. In the past, marijuana enforcement was much greater against minority communities, especially African American communities, and that's exactly how we expect this to be applied as well. Thank you for your time.
All right, thank you for that. No, can you correct me then on this then? So I thought it was all, that the amount for cannabis in the statute was not enough, but it is enough. I just want to, correct me if I'm wrong.
Yes.
I think you're.
I mean, I have represented people charged with these crimes over my entire 10-year career, and volume is sufficient for distribution. Or for possession with intent. I mean, that's often how the arrest occurs. It is based on the volume of drugs that are recovered from the suspect, and then the charge of possession with intent is filed.
Chair, so as I understand the law, right now, possession of a more serious drug, cocaine, in volume with a gun enhances the penalty, because we are scared, we fear that the possession of a gun, along with the more serious drug, could lead to violence and could lead to people getting injured or killed. Did the state's attorney oppose that enhancement when that law was passed? Do you know?
I have no idea. I don't know when that was
If you had
passed.
if you had a chance to eliminate the enhancement for possession of a firearm in concert with the possession of large amounts of cocaine, would you take a position that we should get rid of the enhancement because that person with the cocaine has a gun?
I can't speak for what our office's position would be on that. We'd have to ask our legislative director.
Well, as I understand this, it's the same thing, only we're talking about marijuana in large quantities, not cocaine. So I'm trying to compare apples and apples. So right now, if you possess large amounts of cocaine, indicating you're trying to distribute it, and you have a gun, it's an enhanced penalty. Why should we not have a similar law with respect to possession of large amounts of marijuana with intent to distribute while possessing a gun?
Whether we would have a similar law or not, I think is still up for debate. What this law does is the same law, right? And this has a 5-year mandatory minimum on it, which is greatly different than what the penalty for distribution would be. You know, Senator Henson asked questions regarding quantity possession with legal handgun ownership, which is a misdemeanor and legal activity, right? And so that is why it should be considered differently.
But my point is that we have decided that with respect to possessing large amounts of more serious drugs, possessing a gun at the same time you're doing that enhances the likelihood that there's going to be gun violence and people are going to be injured or killed. Why do you think we should not enact a similar enhancement for possession of large amounts of marijuana? Do you think that possession of a gun while you have large amounts of marijuana makes it less likely that people would be killed? Or it seems to me what's sauce for the goose is sauce for the gander. What is the problem with that?
Well, I think it's contemplated in the sentencing scheme for the different types of possession. Possession with intent to distribute these more serious drugs is a 20-year, carries a 20-year penalty. That's 4 times greater than the penalty for possession with intent to distribute marijuana, which is the misdemeanor 5-year penalty.
Right.
Right. But the punishment for having it with the gun is the same, right? The mandatory minimum is the same. And who is going to be serving those mandatory minimums, right? That is one of our, I mean, that's our greatest concern for this.
I see. Thanks for your answers to my questions.
Yes.
What's the personal use amount right now? Is it 2.5 ounces?
The thresholds are, it depends on how you are, what type you have, I believe, Senator Smith. I believe it's, there's a number, if you're growing your own, it's a certain
you have a
number
couple plants, like 3 plants?
plants. Although the number of plants, usually what a plant can create is higher than the
personal use
amount, even one plant by itself.
So you got plants and you got a gun.
Yes.
All right. There's a distinction in the statute between all other drugs and cannabis, and it's confusing me, but we'll talk about it offline.
Okay.
All right.
Thank you, Senator.
Okay, thank you very much.
Thank you all for your time.
Cool. Thanks, Senator Henson. It's good questions. All right. No, they're really good questions. Maybe. All right. I think that's it. So that'll conclude the hearing for Senate Bill 407. I think Senator Gile, you're 406, sorry. Yeah. Now we'll go on to Senate Bill 407. Senator Gile, thank you.
Yes. Almost done. Mr. Chair, I have a panel also who will be joining me. What else do we have? Hi, how are you? All right. Mr. Chair and members of the committee, for the record, Senator Don Guile here to present Senate Bill 407. This bill was something that I've worked on extensively with Chair Sandy Bartlett, who is my cross-file on. This bill kind of grew out of an incident that occurred in my district involving a teacher who is alleged to have abused a number of students at a school, a teacher who my daughter had. And I'm pleased to present this bill. Senate Bill 407 addresses a narrow but critical deficiency in Maryland law involving sexual grooming and abuse of children under the age of 13 by persons in authority, when that conduct occurs outside of a formal care or custody setting. If a child is abused while in the care or custody of a person of authority, Maryland law already addresses that conduct. Senate Bill 407 focuses on situations where a person in authority uses their position to groom or sexually abuse a child outside of that setting or reaches out to a child with the intent to do so, engaging in conduct short of penetration. Current law provides inadequate penalties for these egregious acts, permitting prosecution for a misdemeanor with a 1-year penalty or an age-based felony with a 10-year penalty when a child is not in the authority figure's care. By contrast, if the child is in the person's care or supervision, the penalty is 25 years. This is too large of a gap. Persons in authority who offend against children under 13 should face serious penalties, and prosecutors should be able to keep them out of our communities. As explained by the Maryland Coalition Against Sexual Assault, sexual abuse often begins with grooming, testing boundaries, and building trust, particularly when the adult holds authority over the child. Existing law does not always clearly address that conduct when it occurs outside of formal care. Recent incidents, including the one I just described in Anne Arundel County, brought attention to this issue, but the gap exists statewide. Children across Maryland are vulnerable to grooming by persons in authority in many settings. Senate Bill 407 ensures that Maryland law protects children under 13 appropriately and reflects how abuse actually occurs. I have a number of advocates here on this issue who will talk more extensively about the bill. Their work with survivors informs this bill, and they will explain why this update creates a more just and proportional response to young children who are sexually abused. You also hear from a friend of mine, a dear friend of mine, and a constituent of District 33 who will convey the powerful impact of this legislation on Maryland families. And for these reasons, I respectfully request a favorable report on Senate Bill 407. Thank you, Mr. Chair.
Good afternoon, Mr. Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 407. Thank you, Senator Guile, for your leadership on this issue. I want to also acknowledge Chair Sandy Bartlett, who has the cross file, and also community members who are really deserve all of our thanks for coming forward. It's very hard to have a horrible tragedy and turn it into change, and we appreciate that courage. You know, almost everyone in this room has seen some sort of person in authority bill before. And I just want to acknowledge the committee. You guys have worked so long and so hard to address this issue and get the balance right for persons in authority. And I want to remind you that there are a lot of discussions that people had about people who are close in age, persons in authority and people who are close in age. That is not this bill. This bill is about children under the age of 13, and the offender still must be 21 or 22. It's also for subsequent offenders, so this is not, that's any age, but subsequent offenders. So this is not somebody who had an inappropriate, criminally inappropriate relationship once. This is someone who has had repeated inappropriate relationships, sexual misconduct with people in their care. And so we want to have a better punishment for that. The other thing I wanted to just point out, that technical issue, everything you've worked on, all of those discussions, they're in the capital letters in this bill. This bill has this very technical, let's get this language out of 3301 and put it into its own section, because in the field, it is confusing the way it is written right now. And so we wanted to move that into its own section so it's easy to understand, but that's your work. All of the balancing that you did is there. The other thing it does is it adds that section, the new section 3301, to sexual solicitation of a minor. That's going to allow us to capture those grooming activities that are so important. For these reasons, we ask for a favorable report on Senate Bill 407.
Good evening, Mr. Chair, committee members. My name is Joyce King. On behalf of the Maryland States Attorney Association, I am the Deputy State's Attorney in Frederick County, and I've been prosecuting child exploitation cases for 14 years. And I do want to echo the sentiments of Ms. Jordan. This committee and Ms. Feinstein and I have come out to Annapolis over many years and worked very hard. And thank you, Senator Love, for championing this statute. And this is your language. And more than ever, we need to emphasize that this needs to be a standalone bill, that when you are sexually assaulted by a person that you've trusted, that has authority over you, when a child is assaulted, it should not be called fourth-degree sex offense. It should be called sexual assault by a person, position, and authority. And I think first and foremost, as a policy and as a message to the community, that is why we are asking for a favorable report. In addition to that, of course, enhanced penalties are necessary. We see recidivism. We see that these individuals place themselves in positions of trust. They move from camps to different types of counselors, to different types of summer camps, music teachers, karate teachers. They are placing themselves in position where they have access to children. And we need to have a harsh response for these multiple offenders. My colleagues are going to address the opposition. Yes, there are other tools, but this does, the movement of this and the language of this statute does satisfy the gaps that we find when children are not under the custody and care of that adult, when they are groomed and moved off-site out of the establishment where they work and they're being molested. So this statute covers that, this bill covers that, and we ask for a favorable report.
Good afternoon, Chair Smith, members of the committee. My name is Debbie Feinstein. I'm a prosecutor with Montgomery County and chief of the Special Victims Division there. I'm testifying on behalf of my office as well as the Maryland State Attorneys Association. I've been a prosecutor for almost 26 years and have had a lot of opportunity to prosecute these cases, and personally worked and advocated for the changes that we saw in the last couple of years with respect to Statute 3308, fourth-degree sexual offense. I want to address a few things that are raised in the opposition to this bill. One of the primary things that FAIR seems to have a problem with is the fact that there is going to be duplicate charging, or going to have double jeopardy, or no merger of offenses. I want to say to this committee that is not accurate. When we talk about duplicate charges, that's already the structure that's set up in sex abuse offenses that are outlined in the statutes that relate to sexual abuse and sexual assault. And I would liken this to the way that we look at cases where someone is in a position not just of authority, but also in care and custody. That individual, if they sexually exploit or molest a child under the age of 18, we're charging sex abuse of a minor in those cases. We're charging 3602. We don't have something similar when a child is not in care and custody. It is a gap in the law, which is why we've tried to make 3308 stronger, but it's frankly not strong enough. The fact that someone can specifically groom a child, move them out of whatever the environment is that may have placed them in care and custody, or they were never in care and custody, and that they would get the benefit of a law gap simply because they weren't in care and custody, because they were only a person in position of authority, is simply not right, and really denies access to justice for these younger children who are really at the behest of someone that is in authority over them while they may not be in a care and custody type of a role. So really, with respect to, I will continue to talk about the opposition if people have questions, but I wanted to kind of point out that contrast between, or that actually similarity between how we charge sex abuse of a minor and underlying rape. This would be the same thing, charge person in position of authority, and perhaps a sexual offense in the third degree, or perhaps a rape if that applied as well. Thank you for your time this afternoon.
Mr. Chair and members of the Judicial Proceedings Committee, my name is Catherine Uhas, and I'm testifying in support of Senate Bill 407. Individuals who are in positions of authority over a child should be held to strict standards and expectations in order to ensure that they do not abuse the power that they inherently hold. There are a number of behaviors that are inappropriate for a child to experience, and yet, as the current law is written, individuals in positions of authority may not be held accountable for those behaviors because they do not rise to the standard of being illegal. SB 407 aims to set clear boundaries for individuals who are in positions of authority to protect children and guarantee that adults who are found guilty of engaging in inappropriate behaviors are held accountable and unable to hurt additional children going forward. In 2024, my community in Severna Park was impacted by devastating allegations. In the span of a few hours, our sense of safety was torn apart by horrific allegations of sexual abuse by a teacher at a local elementary school. Over the course of the next year, my daughter and many of her classmates, our friends and neighbors, were exposed to a system that is not made for children. In the aftermath of that experience, we as community members realized how many gaps exist in the current law. Behaviors that any parent would recognize as inappropriate were not technically illegal and therefore could not be prosecuted. As parents, we assumed that the law would protect children in any and all circumstances. As we learned, the current law falls short in many ways, potentially allowing predators to continue grooming children without penalty. This is disgusting and inexcusable. To the extent that we value the sanctity of childhood, we owe it to our children to allow them to grow up in a safe environment. SB 407 increases the penalties for sexual offenses involving a child and will make our communities safer. There should be no gaps in our laws when it comes to sexual offenses, particularly when committed against children. I am hopeful that this bill will serve to protect my children, as well as the children, grandchildren, neighbors, and friends of everyone in this room. Thank you for your time.
Mr. Chair, I guess, Ms. Jordan, I'd like to ask you a couple of questions if I could, because we've worked together in past years on earlier variants of this bill, and we spent a lot of time agonizing over the alleged abuser who is just a little bit older than the person who's abused, and how many years have to separate them, and because we want to prevent actual loving relationships from being criminalized. It was very complicated, and I think we succeeded finally. So this bill, it looks like you've stricken all the language that we adopted before, but then you reincorporated the language in a different section of the code. Am I right on that?
I wouldn't even call it reincorporated. It's a cut and paste job.
Cut and paste.
It just, yeah, it's exactly all of those discussions. Everything is there. And again, this is because we're finding in the field, putting it in 3301, calling it a fourth-degree sex offense. It's just not really workable.
Okay. So as having been cut and paste, we have the 6 years younger standard. Mm-hmm. So the perpetrator has to be at least 21, mm-hmm. and the victim would have to be at least 6 years younger, which would be 15 under 15. Could be as young as 15 for a 21-year-old. Mm-hmm. But then this bill addresses someone who violates the section involving a child under the age of 13. Mm-hmm. Are we missing 13 and 14-year-olds in the process of doing all this reorganization?
So a couple of things. One, there is actually a certain category of the older person who has to be at least 22. So I don't want to fail to point that out. Right. But what this bill does is it says everything is the same, but we're going to identify children under 13
as a special category.
As a special category, and if you sexually molest this child under 13 and you are a person in authority, which is all the same, right, then you're going to be subject to a higher penalty.
To a much higher penalty. So we're not eliminating the 13 and 14-year-olds. They're still covered under the original language we adopted a couple of years ago.
Correct.
So all this bill is doing, so I can figure it out, all this bill is doing is adopting a higher penalty for sexual abuse of a child under the age of 13.
It does three things. Okay. It does that. It also increases the penalty for a subsequent offender.
Okay.
So, and the subsequent offense covers all of the kids, so any minor.
Right.
Who would be covered before, which would incorporate the 6 years younger and all of that. And then the third thing that it does is it adds this new provision, this new section the cut and paste job into sexual solicitation of a minor, which I think really gets to our community members' point about we need to cover commanding, authorizing, urging, enticing, requesting, or advising a person by any means. When a teacher is doing that to a child under 13, we need to cover that under sexual solicitation of a minor. Other states call that grooming. It's just a nomenclature issue.
Okay, thank you for clarifying the statute. As written, it was confusing to me, but you've clarified it. I appreciate it. Thank you.
The penalties under solicitation stay the same. We slid this new section in?
Yes.
Not that I'm advocating for lesser penalties. Okay. Questions for the committee? Senator Sidner.
I'm asking because let's say I'm a little slow in understanding how moving the exact same language out of 3308 and creating this 3308.1, how it makes things better and what it is that you're.
May I defer to Ms. King?
Thank you.
I'll give you a specific example from Frederick County. We had a school bus driver that is obviously in a position of authority over the students, 12-year-old girl, and he sexually assaulted her on the bus, pled guilty. On his record, it just says 4th-degree sex offense. And he got a probation before judgment, so he doesn't have to register. So that person has the ability to get any job. On its face, it doesn't look like he used his position of authority. So I think by calling it what it is a higher level of accountability to that offender. It is a notice to the community, and most importantly, it's for the victim to understand that they were victimized by a person in authority over them. There's a minimization calling it 4th-degree sex offense.
So why did we choose to do it before? Why was it advocated to do it that way before?
I think that we were working on some larger, we've been working on this language and this statute for many years, and there were many gaps, and we've worked very hard in closing those gaps, and this is the next one.
We'll talk about it later. Thank you.
Further questions from the committee? All right, well, Katie in particular, thank you very much for coming in and sharing your story and coming in to advocate. Appreciate it. Thank you, Senator. Thank you to the panel. With that, I don't see anyone signed up in opposition. Do we have anyone signed up? Okay. With that, that'll conclude the hearing for Senate Bill 407. We'll now move on to our last bill of the day, which is Senator Folden, Senate Bill 437. Senator Folden, you're up.
If you guys want to, I can just make it easy for everybody to leave early, just move favorable. There you go. Thanks for coming up. I'll try to speak quickly. Mr. Chair, esteemed colleagues of Judicial Proceedings, for the record, William Folden, State Senator representing the 4th Legislative District. For us today, Senate Bill 437, dealing with theft and fraud crimes and the valuation of forgery of gift cards. We've had a growing epidemic, if you will, of where we're seeing theft of gift cards and people are losing the value of their gift cards through different schemes. And this bill simply provides guidance for law enforcement and with clear tools that they need to investigate and for prosecutors to prosecute and deter this type of ongoing activity. There's several different examples of it, and I'll just touch on them briefly. I know my speakers are much more well-versed in this, but you have gift card tampering, which is the in-store skimming, criminals removing gift cards from store displays. They record or scan the card numbers and pins and secretly return them back to the rack. Once a customer or a consumer activates the card at checkout, the criminal then drains the balance remotely, sometimes within minutes. and the person that bought the gift card is deprived of their actual paid purchase. Theft of activated gift cards. Cards are stolen after activation, either through employee theft, organized retail theft rings, or interception during transport or storage. These cards are quickly resold and used before the theft is detected. We have victim-assisted scams, where they are deceived into purchasing gift cards and sharing redemption codes. Common versions include those calls that, unfortunately, scammers will call. They target elderly, and they will ask them that, there's been some as egregious as saying that their loved one has been arrested and that they need to send Western Union certified funds, or they will identify as the IRS. The IRS doesn't call and ask for that, and they'll tell them that they're in arrears and that they need to settle up now. And so there's multiple iterations of this: utility shutoff threats, tech support scams, romance scams, employer or family emergency impersonation. That's the one that's really, I've seen firsthand how impactful that can be when they call and say that their loved one was involved in a DUI, was hit by someone, or that they were arrested for hitting someone, and that they're trying to resolve this, amicably, and it's going to cost them $15,000 or the like. As long as they send it, they'll be taken care of, and they'll get it to them in the hospital. Then you have another open loop gift card laundering. These are your Visa and MasterCards are especially attractive because they function like cash. Criminals use stolen or fraudulently obtained cards to buy high-value goods, which are then resold for cash on secondary markets. Organized retail theft conversion. We've had a number of conversations about organized retail theft in this committee, and what we're seeing now is that through the organized retail theft, that they're becoming more sophisticated and with a purpose. And now what they're doing is they go in, they steal the items, and then they will take and return the stolen merchandise for a gift card credit to get a balance. And that affects all of us, because at the end of the day, it's an end user that we end up dealing with those increased costs and incurs. It also hurts the smaller mom and pop stores that are specialized, that makes it more difficult for them to function. You have card cloning and digital wallet abuse, which is the stolen gift cards are loaded into digital wallets, which I'm not a digital wallet kind of fella. I know this may shock many of you, but there's probably a number of you here that do use digital wallets, and through loaded into digital wallets, allowing criminals to drain balances without ever physically possessing the card. That's why I don't have a digital wallet. And then you have insider or collusive fraud. Employees may activate cards without payment, manipulate point-of-sale systems, or collude with outside actors to steal balances before legitimate customers can use them. So SB 437 directly addresses these challenges by clearly criminalizing the gift card theft and establishing penalties tied to the actual value of the card, or a default value when none is listed, as well as the losses suffered by the victims. It would make gift card tampering a misdemeanor crime, helping ensure these products remain secure and trustworthy to those purchasing them. Last year alone, 11 states passed bipartisan legislation, with half of the country introducing legislation for the very first time, as this is a growing concern in our community. SB 437 is a targeted, practical response to a rapidly expanding crime, and it is for these reasons that I would urge your favorable report on SB 437, and I'm happy to take any questions after my panel. Thank you.
Good evening, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are here in strong support of this legislation. So, as you may recall, Maryland became the first state 2 years ago to pass strong gift card packaging laws aimed at addressing growing gift card schemes. Those reforms were an important step forward in combating practices like draining, which you just heard about, or even some of the senior schemes that we've all heard about and are very familiar with. But despite these efforts and other significant efforts by card issuers, retailers, and law enforcement, these criminals continue to evolve. They adapt quickly, exploit gaps within the law, and stay one step ahead of existing safeguards. And this is exactly why additional legislative action is needed. You heard how many states have moved forward, including our neighbor to the south just very recently. And they've all strengthened their laws to give prosecutors much clearer tools to combat gift card fraud. So this bill in its current form attempts to do 4 things. Address the theft of gift cards before they are activated, to deal with the possession of stolen gift cards or obtaining their information by false pretenses, the fraudulent purchase of goods using drained cards, and 4th, the forgery or alteration of the cards themselves. And I said the bill attempts to do this. We have been working with amendments. There are some language tweaks we believe need to occur here. We worked with council previously on language. As soon as we have that correct, we will follow up with every member of the committee and share that with council. But we urge a favorable report. This is much needed. The majority of the country is seeing legislation introduced around this just because we do not have laws on the books around it. So I'm glad to answer questions. Urge a favorable. Thank you.
Good afternoon, almost evening for the esteemed members of the committee, Mr. Chair, Mr. Vice Chair. My name is Morgan McLaughlin. I'm an Assistant State's Attorney for Frederick County. I'm speaking here on behalf of the Frederick County State's Attorney's Office, as well as the Maryland State's Attorneys Association. We advocate for a favorable adoption and recommendation of this bill. It is much needed. To piggyback a little bit off of what has already previously been testified to, the schemes that happen involving these gift cards, these are not like even some of the organized retail theft we've seen recently where people go in and just steal merchandise from retailers. In fact, this is usually a much more complex, organized, and targeted offense. It's very, very directed. And so for all those reasons, we think it's very important to address that. I would say what I think is of particular note here is that many of the victims here are not retailers themselves, but it's actually the consumers who buy gift cards thinking they'll be able to use them for whatever it was they purchased for gifts, anything of the sort. Or if it's people who are being scammed out of money through various schemes over the phone or things like that. I just recently had a case, probably within the last few months, where an elderly woman was contacted saying she had warrants for her arrest, and she ended up sending about $5,000 to these scammers, and it wasn't until she went to the Frederick County Sheriff's Department that she realized that was completely bogus. So I understand it's late in the afternoon. I don't want to take up too much of everyone's time. Thank you for the opportunity, and I would request a favorable recommendation of this bill. Thank you.
Ms. Locklear, maybe I could ask you this. Yeah, because I've heard bills along these lines before about these scams. I have been in a position where I would have liked to have bought gift cards in Walmart or places like that. Sure. And I have passed by the racks fearing that the card that I bought would be a scam. Is there any way for the retailers to periodically check their cards to make sure that they're real and they're not going to defraud people who buy them?
Thank you for that question. So Senator Kramer actually sponsored a bill that you all passed 2 years ago now. Maryland has the most stringent packaging standards in the entire country now. So that redemption information is always what criminals are after. And for a long time, unfortunately, the security on the backs of gift cards might have actually just inadvertently exposed that, or it was very easy to just kind of peel it back or remove any sort of covering on it. Often what we see criminals do, though, is they will steal a bunch of them. They will take them home. They plug the information into a system. They repackage them the exact way that we do using all of our materials, bring them back into our stores, and then you go to purchase that gift card, and the second that you swipe that, they have a system that's constantly pinging that gift card that was plugged into a system, and those funds are drained in 2 seconds and go away. I would just say, though, the packaging language that Maryland passed makes it so that it is very difficult without you knowing that the card has been tampered with and that redemption information has been exposed now. There's brand new technology that we've rolled out, but quite frankly, it doesn't matter what technology we roll out. They're always going to find a way around it. And the fact still exists that we do not have statutes on the books to deal directly with these cards being stolen or the, how many different crimes did you just outlaw here? I think it's 7 different schemes, and our laws do not cover all of those different schemes.
So, well, I'm happy to pass this bill, but I'm not sure you've reassured me that I should feel safe buying gift cards.
I'm glad to follow up with you and show you some of the technology that we've rolled out. And like I said, Maryland is the first state that has all of that information, hopefully to make you feel better too. The other 2 requirements that you all passed in that legislation included retailers training our employees to help identify any of these activities. And then I don't know if you've noticed this within the past year, but on every single one of those end caps that has any sort of gift cards or a gift card display, we are actually obligated to put signage from the Attorney General informing consumers of schemes and that schemes exist and that they need to check their cards. On the back of the cards now too, we also have to have a disclosure about that as well.
Okay, thanks so much.
Mm-hmm.
Just a quick question for Mr. McLaughlin. Generally, I'm curious how, if this were to happen to an individual, if your state's attorney's office, if you all would actually make this a priority to prosecute on behalf of the consumer. And the reason I'm asking, generally, if you have one state's attorney, usually also seeing testimony from the Maryland State's Attorneys Association, and I notice you're the only state's attorney's office that's represented. So is this a priority for the state's attorneys?
Thank you for the question, Senator. Yes, it is a priority. Obviously, I think in recent times, especially with cost of living and how tight everyone's budgets are, I can certainly speak for my office, but in conversations with others, this sort of fraud is a priority, and we certainly want to take it very seriously.
You all will put the resources in if it happens and the consumer brings it to your attention?
What was the question, Senator?
I said you would make it a priority if this happened to a consumer and brought it to your office.
Of course, Senator, yeah.
Thank you.
All right. Seeing no further questions from the committee, thank you all very much. Thank you, Senator. With that, that'll conclude the hearing for Senate Bill 437 and our hearings for the evening.